Hear ye, hear ye. All persons having business before the court are drawn near to their attendance, and they shall be heard.
Thank you. Please be seated. Before we begin calling cases on the calendar today, we have two candidates for admission to be sworn in as attorneys and counselors at law. Ann Dillon Flynn, the clerk of the court, will administer the oath. Ms. Dillon Flynn, have these candidates been certified to the court for admission by the appropriate committee on character and fitness as possessing the character and fitness required by an attorney and counselor at law? Please administer the oath of office. Congratulations. Counsel, we wish you nothing but success in your careers. You've got wonderful things ahead of you, I'm certain. Congratulations, and have a great day.
Thank you so much.
The first case on for argument today, case 957, People versus Case.
Good morning, Your Honors. May it please the court, Leah Farwell for Appellant Michelle Case. This case appeals from a Genesee County Court decision from 2019 ordering her to pay over $25,000 in restitution to her former employers and their insurance company. Over $11,000 of that amount was related to personnel costs, and these personnel costs were merely expenses related to being a party in a trial, hotel rooms, copying costs, things like that, merely expenses, as I said, related to being a complainant. Further, Ms. Case was essentially ordered to pay her former coworkers' salaries as they spent their work hours investigating the claims against Ms. Case. Just as a preliminary matter, this issue is preserved for this court's review by defense counsel objection. I'd like to focus on point one of my brief. Restitution should not be a windfall to the complainant. Salaries that the employer would have been obligated to pay anyway and costs incurred while testifying at grand jury hearings and at trial are improper components of restitution.
What if the victim had to pay overtime or more hours for employers to investigate it? Would it be different there?
No, Your Honor, respectfully, I don't believe that it's different there. I understand that your question is about overtime for, I believe the employees who were investigating these claims. I don't believe any of them had to put in overtime hours. They completed this investigation during the normal course of business, during their time at work from 9 to 5. And the reviewing court must consider if a defendant was penalized for exercising their right to go to trial. And it is clear that Ms. Case was penalized here. She exercised her constitutional right to a trial to fight the charges against her, and she was penalized. She was ordered to pay essentially the salaries of her former coworkers, and that's not right. That's not what the criminal justice system was set up to do. And that kind of precedent hurts indigent defendants.
Well, it seems to me really your better argument is it may not fall within the definition of restitution or what restitution is supposed to do. I don't know that I would agree with you that we view it as a penalty.
Your Honor, I agree with you completely. This is not what restitution was ordered to do. Restitution is, defendants are required to make restitution of the fruits of their offense or reparation for the actual out-of-pocket loss caused thereby. What occurred here is not out-of-pocket loss incurred by HC&H.
Because they had to pay the salaries anyway.
Exactly, they had to pay the salaries anyway.
And expenses Judge Noonan cited People versus Dunno, a third department case.
I'm sorry, could you, the third department, Donna?
Yeah, Dunno, the trial court relied on a case from the third department
Yes.
where they approved the expense, the defendant had to pay the expense of the victim's mother flying up from Florida or Texas to speak at sentencing. That would seem to support the judge's ruling here with regard to the trial expenses, would it not?
Yes, and I disagree with the contention that it supports restitution for the trial expenses, because the complaint, believe it was the complainant's mother who had to fly from Texas to New York. She had a statutory right to do that, just as Ms. Case had a constitutional right to have a trial and present her case to the judge. The restitution, as I have been saying, should not be a windfall to the complainant. These salaries that the employer were obligated to pay anyway and costs incurred while testifying are improper. And in fact, they were necessarily incurred as part of the criminal justice system. Ms. Case was essentially penalized for exercising her constitutional right to a trial when she was asked to compensate HC&H employees for testifying and investigating the claims against her. The claims against her.
You don't have a problem, excuse me, you don't have a problem with the money that was stolen, found to be stolen, the $13,000, $14,000 that was stolen. You're not challenging that, are you? For
Your Honor, we
restitution?
take no position there.
What's that? You take?
We take no position there. The costs were far too attenuated and were improperly shifted to Ms. Case here. They were attenuated from the offense and from the original offense that allegedly occurred. I respectfully ask this court to vacate or reduce the restitution order, and unless the court has any further questions, I rest on my papers.
Thank you, counsel.
Thank you so much.
Case 960, People versus Kemp.
Good morning, Your Honors, and may it please the Court, Sarah Goldfarb on behalf of Mr. Benjamin Kemp. Reversal is required in this case because the lower court erred in denying the causal challenge to potential juror Mr. Fenskin. During voir dire, this juror made numerous statements that cast serious doubt on his ability to be impartial and unbiased. He stated that to kill someone is pretty brutal, and a person who does that must have gone into a situation thinking he could potentially kill someone, and he also shared his belief that premeditation and intent were one and the same. The prosecutor tried to rehabilitate this juror on multiple occasions, but the juror kept returning to his opinion that a person should not put himself in the situation where they might commit a crime, because to him a crime was a crime. When a prospective juror reveals a possible bias like this, that juror must be excused unless they can provide unequivocal assurances that they can set aside any of their biases and render an impartial verdict on the evidence and the court's instructions. And here that did not happen. Instead of questioning the juror directly, the court appeared to rely on a question that the prosecutor had asked to the panel as a whole. And this was insufficient for two reasons. First, because there was nothing on the record that indicated that that juror even responded to that question. And second, because both this court and the Court of Appeals have indicated that questions to a whole panel of jurors is just insufficient. You have to really put a spotlight on that one juror who has expressed those biased opinions to get him to really evaluate his beliefs and determine whether he can set those aside in order to evaluate the case.
We'll take a look at that issue. Could you address the suppression of the statements that it made to his father?
Yeah, sure, of course, Your Honor. I'm assuming you also don't want me to discuss Batson?
No, you can get back to Batson if you have time, but I'd like to hear from you with respect to the statements.
Sure. The statements in this case the statements that Mr. Kemp made to his father in the interrogation room should be suppressed because they occurred after Mr. Kemp had invoked his right to counsel and had asked for the police to stop questioning him.
But in this particular case, we have a situation where the father's with the young man, who's I think 15 at the time.
Correct.
Right? And I think there was an indication early on and looking at the video, where the son was having a tough time understanding at least the Miranda rights at first, until the father kind of explained it to him. And so the father was there assisting the son. As soon as he invoked his right to counsel, the officers moved out of the room. I mean, there was an odd comment. I thought, we'll have to see what's next, or what we do next, or something along those lines, which I didn't quite understand. But once out of the room, wasn't it clear that the father had advised the son that, be careful, there's cameras? And how does that impact on your argument?
I don't think it should matter, Your Honor, that the father told the son, you know, there are cameras here looking at us. This is still the private communications of a son and his father. And there are cases from this court and the Second Department sort of really recognizing that important relationship between a parent and their child. In the Harold case,
Was there an effort in the video? It seemed to me that when told that there were cameras, the son was moved closer and tried to kind of shield his face from the camera and trying to talk to his father to get his advice, presumably. Does that make a difference?
I think that does, because, you know, shielding away from the camera, lowering his voice is really an attempt by the son to sort of shield their conversation from being overheard, whether from outside of the room or from the cameras that we're watching.
It seemed like the defendant may have thought there's cameras, but not audio. The father said there's cameras here, and the son, it sounds like, because he covered his mouth, but he kept talking, was probably thinking, well, they can't hear me. Cameras can't hear standing alone. So in other words, what the argument's been made is, well, he knew about all this and he spoke anyways, but it sounds more likely that he knew there was a camera but not audio. Is that fair to say?
That's certainly, you know, a fair thing that can be taken from the video. I wouldn't, you know, presume to know what Mr. Kemp was thinking in the room. I think that's a fair interpretation of it.
But if we're trying to determine whether or not he, you know, waived essentially his right to a quiet, confidential conversation with his father, it seemed, the video seemed to indicate that he wasn't doing that. He wasn't waiving it.
Correct. I do not think he was trying to waive it. As you mentioned, he did cover his mouth. He might not have been aware that it was recording the audio. In any event, you know, this is a scared 15-year-old child who's trying to figure out what to do, what the best course of action is, and he's trying to get the counsel of his father when they're outside of the direct, you know, interrogation of the police officers, what he knew about how much the video camera could catch. Maybe he thought he could prevent it from hearing what he was saying to his father, because in that moment he was a scared 15-year-old looking for guidance about what to do in this situation he found himself in. And so for that reason, we would ask that those statements that he made be suppressed, because he was trying to shield his conversation. Additionally, do I have time to mention Batson and the sentence? Or?
Go ahead.
Okay. Additionally, the prosecution committed a Batson violation here by striking 3 of the black jurors in a row without providing a valid race-neutral reason for doing so. The prosecutor removed the first black potential juror because he didn't answer a single question during voir dire. But again, this juror wasn't asked a single question during voir dire.
Right. We understand the record, and then the second one didn't speak fluently enough, and the third one was too young for the prosecutor. But does the record show whether there were any other blacks, prospective jurors, and if any made it to the pool or made it to the jury?
The record isn't completely clear. I believe at least for the first 2 jurors, they were the first 2 black jurors to come across the panel. I believe the same is true with the third juror. I don't know if there were other potential black jurors sitting in the room, but at least with the first 2 jurors, it was one after another. And so for that, we would encourage this court to consider the totality of the relevant facts, especially the reasons given for excusing all 3 jurors in total when evaluating that Batson argument. And then finally, if I could just mention the sentence really quick. Mr. Kemp was charged as a juvenile offender, and he was 15 years old when this crime occurred. That made his sentence of 15 years to life the maximum he could have received. And we would urge this court to reduce that and let him go before the parole board in 7.5 years. He faced significant adversity in his life and lacked the parental guidance that might have helped him deal with the significant trauma
We'll
that
take
he
a look at that,
faced.
counsel. Thank you.
Thank you, and if this court has no other questions, I rest on my brief for all
No
other
questions,
questions.
counsel. Thank you.
Thanks.
Good morning, Your Honors. Brad Osler for the people. I'll start with the suppression issue. I think it's difficult for me to imagine how the defendant, even being 15 years old, could have any reasonable expectation of privacy in the setting that he was in. He's in a police station. He's in an interview room, having just spoken to a pair of detectives. And then
We've got a circumstance here, though, where we have a 15-year-old, and we have rules set up that we have to get their parents in there, right?
Mhm.
Because they can't be trusted to react in a way that would be adult-like, right?
absolutely, yeah.
Right, and so doesn't that factor come into play here? I mean, he appears to be shielding his face. When he's told there's a camera, he shields his face. He wants to talk to his father. He had trouble understanding the Miranda warnings. His father had to interpret that for him. And in my view of the video was, he was taking strict guidance from his father. When asked the question about whether he should be asking for a lawyer, he turned to his father and said, "What would you do?" He said, "I'd ask for a lawyer." He says, "I'm asking for a lawyer." I mean, he was responding exactly the way the father was. And he was a young man in a very difficult circumstance, and he was trying to talk to his father. And isn't that why we have the parent present?
I would agree, Your Honor, that the defendant did show a great deal, I think, of reliance on his father for guidance in the situation. Certainly unsurprising, I think, given the circumstances. Given the framework by which we would evaluate the parent-child privilege in this, under our existing law, we still have to look at both the reasonable expectation of privacy, and then, and kind of dovetailing on what I was saying before, when his father is saying, "Be careful what you say," they're pointing at the camera, making him aware. And I would agree that I would be speculating whether or not he's aware that there's audio recording as well versus just video.
There's no indication that he would know that.
No. But in any event, he's clearly aware there's a recording device, and it's sort of puzzling to me. But his dad seemed to kind of continue to engage him in a conversation in the room, despite their knowledge of the camera.
My view of it, he was kind of reacting to his son asking questions, and he was responding to him because his son was asking questions. He was trying to respond to him and be there as a parent.
Yeah, absolutely.
Yeah.
But I think it's, again, based on the framework by which we would analyze this, especially once even if he is relying on his father, they both collectively certainly have knowledge of the recording device, and I don't see how in that circumstance.
But for the father's statements to his son about the camera, about the presence of the camera, but for that, there would be suppression here. The defendant invoked his right to counsel. He's having a private communication with his father. The police are listening and surreptitiously. That would be suppressed.
It wasn't challenged on that ground,
I know,
interestingly,
because
but I
mine are
would.
different facts. I'm
Yeah,
just
but
asking you
I would.
hypothetical.
I would suspect that might be
Right.
susceptible to
So-
suppression.
Right, if the father hadn't warned him about the camera, so then it turns on, what did the son know when he spoke? He knew about a camera, but he didn't know that anyone was listening. So it doesn't seem to change. The knowledge of the camera alone for a 15-year-old doesn't seem to change a lot for me.
I would disagree only insofar, Your Honor, as I think it is somewhat speculative as to the knowledge of audio versus video recording. I'm not a 15-year-old, so when I see a camera, I'm sort of assuming it might be recording both, or at least there's a chance. And I don't know what he or his father may have been thinking at that point in time, but
It would have been much easier had the officers, before they left the room, said, after invoking the right to counsel, had said, "There's a camera recording you and everything you say. We're now going to step out of the room." But they didn't say anything about that.
no.
And so
No, they
the
didn't.
people with the information about what the recording device was and what it was doing, whether it was video, audio, or both, was in the control of the officers and they didn't share it.
Correct. I'm not sure they're exactly under an express obligation to do so.
But to the extent they want to use this information at trial, and to the extent that they want to say that they waive their rights, it would seem to me, in fairness, that they would disclose to them that there was a recording device, both video and audio.
I would agree. I think there conceivably could be an issue with respect to the invocation of, well, or at least the invocation of his right to an attorney, certainly. But again, that wasn't really the litigated issue here.
Police could have also turned off the device. This is akin to me, somebody invokes their right to counsel, parent comes in, the police are out in the room with a cup up to the wall or to the door listening in. They intentionally went to go listen to what was being said.
I don't know if they didn't. I don't know the intention, the exact intention of the officers. I'm uncomfortable suggesting that they
That's fair.
were engaging in some sort of surreptitious, intentional activity. But understanding what actually happened, I recognize that the invocation of his right to an attorney could result in suppression here. The challenge, though.
Let me just interrupt you for a second. You've said a number of times, it's speculative for anyone to conclude whether the child, the defendant, knew that there was recording based on the fact that the father said there are cameras. If it's speculative, how does that help you?
I think only with respect to the question of whether or not.
There's a reasonable expectation of privacy.
Well, with respect to an audio recording, as opposed to just a video, which wouldn't obviously reveal.
But right, if it's
any conversation.
speculative, it seems to me that we can't conclude that the defendant had a reasonable expectation of privacy.
I would agree. I think that's part of the problem here is based on the reaction of the defendant and his father to the camera and their obvious knowledge that it was there.
Well, we can't, probably should have phrased it better. We can't conclude either way.
Well,
We can't conclude that he waived it. We can't conclude that he knowingly waived it.
My
He didn't know about
position-
the audio.
My position would be, with respect to that, is that their physical reaction, they clearly are cognizant of the recording device. That is a visible indicator that they're aware that they do not have really a reasonable expectation of privacy to the extent that they could have a sensitive, private conversation in that set of circumstances.
So you're essentially saying we should infer from their reaction that they knew, the father knew, that this was audio and video, and that when he related to the son should have known that, and that should be built in as not speculative, but as facts.
I essentially, yes. I think the father's pointing to the camera saying, "Be careful what you say," or something to that effect.
Anything
That's-
further on that point, or do you want to address?
No,
the
I
other
think
issues?
that's my main point, is I think the reasonable expectation of privacy was missing or absent. I would be happy to rely on my papers for the other points unless
Very
there's any
good.
questions.
Counsel, thank you.
Thank you.
Case 964, Marinaccio versus Town of Clarence. Proceed, counsel.
Thank you, Your Honor. May it please the court. My name is Michael McLaren. I'm here on behalf of the town of Clarence with respect to this appeal seeking reversal of the decision of the court below. I would like to start by pointing out that 2.5 weeks ago, this court decided an interesting case of Walker versus Erie Insurance, and Judge Perodato, I think, was on that panel. And that case involved a plaintiff who contracted MRSA through a pedicure. And the issue before this court was whether or not there was an insurance policy that would have covered that exposure. My firm represented the plaintiff here. Unfortunately, we lost that argument. But the court here held, quote, "We reject plaintiff's proposed reading." And then this court was quoting another court, courts may not, through their interpretation of a contract, add or excise terms or distort the meaning of any particular words or phrases, thereby creating a new contract under the guise of interpreting the party's own agreement. I would submit to you, if this court applies that standard that it set forth 2.5 weeks ago, the lower court here gets reversed. There is no question that the contract here does not contain explicit standards. And what the plaintiff is asking this court to do is insert a standard into an otherwise comprehensive agreement, which everybody agrees is not ambiguous. There are, and I know this court is well aware of the canons of contract construction, but there's two at play here. One is the one I just read to you, and these are set forth in Nomura, the Court of Appeals decision, Nomura. And the first one is the one I just read to you, but the second one I think is equally important, which is a contract must be construed in a manner which gives effect to each and every part, so as not to render any provision meaningless or without force or effect. And that application here is because we have a comprehensive merger and integration clause. And that clause, specifically at paragraph 13 of the agreement, which is at page 109 of the record, specifically says, each party to this agreement hereby acknowledges and agrees that this agreement and the exhibits contain the sole and entire agreement and understanding of all of the parties hereto. It goes on to say, and I'm not going to read the whole thing, but it says, each party to this agreement hereby acknowledges and agrees that no other agreement or representations, written, oral, or implied, other than those expressly contained in this instrument, shall be deemed to exist. And if you accept the plaintiff's argument here that there is some kind of implied 25-year flood standard, you are rendering that provision meaningless.
Counsel, can we at least imply that it was intended that the defendant's work would be workmanship-like or meet the purpose for which the contract was made, which was to divert the stormwater?
Well, I think that the purpose of the agreement, the purpose of the agreement was to settle the lawsuit. There's no dispute about that. That's at the third wherefore clause.
Well, we know that if we're settling a lawsuit, and the lawsuit was based on the fact that flooding was happening to plaintiff's property because of a subdivision.
Right.
So as a result of the lawsuit, you agreed to build a ditch that would capture the stormwater and it wouldn't no longer infiltrate plaintiff's property.
Well,
And they are claiming now that what you did didn't actually fit the purpose it was intended to, which is to divert the stormwater.
well, I disagree with you, Your Honor, because there's nothing in this contract or agreement that says that we would build a ditch that would thereby alleviate any problems with water infiltration at all on his property. There is nothing in the agreement that says that.
So could you have then, let's take the line of the ditch, from point A to point B, crossing plaintiff's property. Could you have, as they somewhat argue, dragged a stick along that line and said, we just made a ditch and we fulfilled the purposes of the contract because it doesn't say anything about how deep or how wide the ditch has to be?
So what we have here, Your Honor, is at paragraph 9 of the agreement. It says that this ditch is being constructed for the purpose of diverting stormwater. So if your line in the sand actually diverts stormwater from Lexington Woods to Lap Road, it complies with that.
No matter how much of the water.
No matter-
Some of the water, but.
Absolutely. That's
As
what,
long as it diverts a measurable amount of what your argument would be, a measurable amount of that water, the rest going on to plaintiff's property, then this contract, as written, is satisfied.
that's exactly right. And that's the only way you can read this. But we're not at this. We're not at.
agree that, Mr. Mayor, that the plaintiff here, nobody in their right mind would agree to such a contract intentionally.
Well,
That they're giving up money, $400,000, and they're giving up land for essentially nothing if the town can just drag a stick through the ground.
well, Your Honor, I think you're making an assumption here that's not fair on this record. that the ditch was conveyed for the benefit of the plaintiff. And you can't make that leap here.
Why not?
Because he settled the lawsuit. He had a $1.6 million verdict.
Right.
He got $1.2 million. It was on appeal. This was a hotly contested case. And if you look at paragraph 9, the first paragraph, the first sentence of that, and it doesn't say, it's not for the benefit of the plaintiff. It says, as a condition precedent to all payments herein, Marinaccio will give us the ditch. It's not the other way around. So the town is basically saying to him, we want the ditch. We want to build this ditch to convey some of the water from this piece of property to Lap Road. And we're not going to pay you a dime until you give us that ditch. There is nothing here that says that Marinaccio, in this agreement, represented by Lipsitz Green throughout the whole process here, ever said, I want this to make my property dry. I want it to convey all the water from Lexington Woods. I want it to convey 80% of the water. He didn't add that in, and
Is
he
it
could
true
have.
that the town, Mr. Mariachi was compensated for the wetness, the increased wetness on his land? That was what the verdict was for, correct?
It was a taking.
Yeah, so the town, am I correct, could have just taken the land, given him the 1.64 and walked away.
Right.
But instead, Mr. Mariachi got to keep his land,
Right.
and he got to keep 1.2,
Right.
and he didn't have to worry about what we were going to do on appeal.
Right.
But in return, he gave up this strip of land to the town
Right.
to build this ditch. So your point is that he's already been compensated. If there's additional flooding on his land, he's already been paid for that.
Well, and the release language of paragraph 3 of this makes that absolutely clear, that he is releasing them from any and all claims of stormwater intrusion on his property, including, if you read the language, any water that comes out of this ditch. So yes, he has been fully compensated for the value of his property.
So that's a no damage argument, which you make as well.
Right.
He's
But I
already-
think
he's already
it-
been paid for his land being flooded. It doesn't matter if it gets flooded anymore. He's
Right.
already been compensated.
But I think it all flows together, because when you look at what happened here, and the fact that there are no standards in here, there's no standards in here because it was the town's option to build this ditch if it wanted to. It had the sole discretion to determine whether or not building a ditch was fiscally feasible. They decided to do it, but there's no standards because Marinaccio, it wasn't for his benefit. And the whole reading of the contract makes that perfectly clear, because if in fact he wanted to add in those provisions, it would have been really easy to do so. His attorney was a smart guy. This was a complex negotiated settlement of a very complex lawsuit with issues that were going to come up to this court that were going to be hotly contested. But I would point out one more thing.
Counsel, so it's not reasonable for us to believe that you would do this work in a manner that was workmanlike and actually had some goals to prevent the water from, I mean, you built a ditch, he says it doesn't work. You say, so what?
Well-
Is that reasonable?
Well, in fact, Your Honor, I think from a theoretical and sort of from that perspective, I don't think you look at those issues. But what we have in front of you is a full record here. And if you look at this record and you look at what in fact was actually done, I know you say that, you just said that the plaintiff says that the ditch doesn't work, but that's not what that's what they say in the brief, but that's not what the record says. In fact, the plaintiff put in an expert affidavit, and the important part appears at 1140 of the record. And his expert says this ditch was built to a 10-year standard, and that it only overflows at one small point of the ditch on a 10-year flood. And what that means is that
If we accept your argument, that shouldn't even matter, right?
Right, exactly. But you have in front of you a factual record that shows this ditch is not a stick in the line. Their own expert says it's not, a paper clip across the sand as they characterize it. It is a ditch that functions. And what his expert says is that there is a 10% chance in any given year that that's going to overflow. Otherwise, he agrees, it carries the water from point A to point B.
What does the reversion, or how does the reversion clause fit into your argument?
I think that if we didn't build a ditch that carried water from point A to point B, Lexington Woods to Lap Road, the property would revert. But since we did,
Why is that clause in the contract, if we accept your argument?
well, because there's no reason for the town to maintain the property if they're not going to build the ditch. So why have the town keep it? I guess if the town wasn't going to build the ditch, the town didn't want it. It would rather have it on the tax rolls, I think is sort of the practical reason why. And it didn't want to have this 30-foot strip of land that it had to maintain as a park or have exposure to. So if they're not going to build the ditch, why keep the land? And it goes back to the plaintiff.
Right.
I
And your
mean, they
argument
gave
is-
them 4 years.
If they didn't have to build a ditch at all, if they could have just left it as is, then surely the fact that they actually built a ditch that withstood 10-year floods is better than if they built no ditch at all.
From the town's perspective, they're moving some water from south to north, which in Clarence is a big deal.
Right. But I'm talking about from the plaintiff's perspective, what the town did, build a ditch that withstood 10-year floods, is better for him, better for the plaintiff than what the town could have done, which is nothing.
Right. That's exactly right. I think that's right.
I think we have that argument, Counsel.
Okay, I would just, again, urge your honors. One other thing is, Mr. Rupp has repeatedly made statements to the court below on the record that he is not going to be relying on any parole evidence in this case at all. And he has now submitted to this court exactly that. Parole evidence in the form of his expert saying, well, you got to incorporate a 25-year standard into this contract. I would ask you to hold Mr. Rupp to his statements to the court below about how he's going to prove his case. Thank you, Your Honor.
Thank you, Counsel.
Good morning, Your Honors. May it please the court. Judge Lindley, I'd like to start just by addressing the question that you posed to Mr. McLaren about whether Mr. Marinaccio was better off with the ditch that was built versus what he had before. He's really not, because this ditch, which was never built to an appropriate standard and never maintained, overflows now deeper into his property than the 2 drainage pipes that ended at his property line that was the focus of the lawsuit that ended with the settlement agreement in 2010. So now that because the ditch is so terribly designed, the water comes out of the subdivision way past the point where those 2 outflow pipes were, gets onto Mr. Marinaccio's property, and then and then floods the whole property.
Right. Well, how do you answer the problem, his concern about your client's already been compensated for the destruction of his land? He can't build there because it's too wet. He's already been paid $1.2 million for that, so additional water, he has no damages now.
Well,
He's already
Judge,
been compensated
this
for that.
lawsuit's not about damages. And this court, and I know that Judge Peridotto was on the panel in 2017, made that abundantly clear, and I thought we tried to plead it that way, but the clarification of this court made it absolutely, positively clear. This is not a case about money damages to the land. We're not seeking that. But we do have expectancy damages for the performance of this. Their argument is essentially we have no remedy, that we negotiated this into the contract, they were supposed to do it, and if they don't do it, if this panel finds that they didn't do it in a workmanlike fashion, then we have absolutely no remedy, and that's not the case. We had the reverter clause, which was a remedy to get our property back. At least then, Mr. Marinaccio, who is a construction contractor, could build the ditch in an appropriate way so that the drainage, which is being inflicted upon him from Lexington Woods, could go to Lap Road. But if I may, Your Honors, and I know that we can argue all day long about what paragraph 9 says about the water being diverted in ditch to Lap Road, I would point out a couple of things. One is the contract refers to this, the settlement agreement refers to this as a drainage ditch, not just a ditch. It is a drainage ditch. And I think that modifier has a meaning and a purpose that is consistent with our argument and inconsistent with the town's. The town's position is if they have a ditch that gets some water to Lap Road, and by the way, I don't even know that they put that in evidence in the record, because part of our argument in our brief is that they never met their prima facie moving burden. There's no expert here other than mine saying their ditch is faulty. But even if they did that, conveying some of the water and dumping the rest of it all over our property is not carry out the functions of a drainage ditch. It is not parole evidence to say, as the court knows, what was the purpose of this agreement. We know that more richly here than in most cases because there was an entire prior lawsuit that resulted in a jury verdict. We know why this settlement agreement was there. It's relating to flooding. We know why the ditch was put in. It was to drain Mr. Marinaccio's property. That is not parole evidence to address Mr. McLaren's comment. It is also, and I have briefed this repeatedly, there's case law cited in my brief, It is not parole evidence to suggest that the work must be done in a workmanlike standard pursuant to industry standards. That is not parole evidence. What is parole evidence is Mr. McLaren's predecessor deposing Mr. Marinaccio's attorney at Lipsitz Green to get testimony about what his personal beliefs were of the settlement agreement, and then putting in draft copies of the agreement as if they have any relevance at all. But my main focus that I'd like to point out now is not about paragraph 9 and 11 relating to what we claim are the standards for this drainage ditch to drain in and through. It's the 3 clauses of this contract that would be rendered meaningless if this court adopts Mr. McLaren's view of what the contract says. The first was pointed out by the panel in 2017, and it is this. Mr. Marinaccio had a right to request that the town allow him to tap into this ditch to help drain his property. So the ditch exists to drain Lexington Woods to Lapp Road, but there was a clause that was, as Mr. McLaren says, hotly negotiated that allowed Mr. Marinaccio to request of the town, and the town could not unreasonably reject that request, to put the flow, the water that's naturally occurring on his property into the ditch to help it get to Lapp Road. Now that clause would be rendered absolutely meaningless if the town could build a ditch that didn't even carry the Lexington Woods runoff, because how would you be able to add to that flow from Mr. Marinaccio's property? If their interpretation is accepted, that clause is rendered absolutely meaningless. I went through the contract very carefully. There are 2 others. The other one that's rendered absolutely meaningless is the reverter clause that says if the town concludes that it is economically infeasible to build the ditch, the property goes back to Mr. Marinaccio. That was addressed in Mr. McLaren's portion of the argument. But think about that. If it's not economically feasible, that suggests or implies that there's going to be a minimum cost here to the town to build this ditch to the right specifications to move the water from Lexington Woods. If there is no economic infeasibility, the town could always just use the paper clip or a trowel or maybe a digger or a shovel or whatever. They could always make this economically feasible. They could just put in the ditch that is. So that clause would be rendered meaningless. If I hope I'm making myself clear and following what I'm saying. There's a certain standard for this ditch that was going to be required. The town had the option to say, no, we're not paying that. If that's what it's going to take to drain Lexington Woods to Lapp Road, forget it. You can have your property back.
The difficulty is, counsel, that you say there is a standard, and I see that argument, but what is the standard according to the contract? Is it a 10-year flood? Is it a 25-year flood? Is it something less than a 10-year flood? What is the standard if it's not in the contract?
Judge, our expert, Joseph Ardietta, who's a licensed engineer who does these types of things, said what the workmanlike standard is when you are told build a ditch and there are no specific specifications for the ditch. This contract is not this crazy thing where, you know, the town took on the obligation to build a ditch and there was just no specifications to it. There were no specifications because the town needed to do a study to see what was coming out of Lexington Woods, to know what it was going to take for the ditch to be able to run that water. There's 2 ways you can do a ditch. You can either build it really deep and really wide so it carries everything, or you can try to design it to the minimum specifications, but then you got to clean it out. There's been no clean out of this ditch, the record reveals, unrefuted, in the 6 years. So they designed it to an absolute minimum standard and then let it become all overgrown with weeds.
This seems to be all parole evidence that you're talking about now.
Well, Judge, no, because
Outside the contract.
I'm sorry, Judge, we're evidence of what is the industry standard, evidence of what is a workmanlike performance of the contract is categorically not parole evidence. And we have sparred about that, and it's true, Mr. McLaren is right, for years. And I keep putting cases in my briefs, in my motion records, saying it is not parole evidence to use a workmanlike industry standard. So our expert said what those standards are. Our expert said it is not uncommon to see an obligation to build a ditch. And when the contract is silent, you build it to a 25-year flood standard. Now, I'm not hanging my hat on that, but that's what he said. What he also said is if you're going to build a drainage ditch, not a ditch, a drainage ditch all the way from Lexington Woods to Lapp Road, you have to build it in a way that's going to convey the water, which means you have to know what's coming out. You have to build it deep enough and wide enough to get the water to Lapp Road without overflowing all over our client's property. So to say that the economic infeasibility thing is meaningless, that they could just...
If that's the purpose of the contract.
Well, Judge, I think
If
that
there's no
has to
water
be...
overflowing. He
Yeah.
says that's not the purpose.
Well, Judge, the other non-parole evidence thing that the court can consider, a court can always consider the context of a contract. And here, as I said before, we have a rich context with the prior lawsuit. It is not parole evidence to show that this contract arose out of a prior lawsuit and the settlement thereof. It is not parole evidence to say that the purpose of this ditch was to remedy the flooding situation that was caused when the Lexington Woods subdivision was put in and literally did its drainage by having 2 outflow pipes that stopped at my client's property line and literally flowed over them. To say that it's not parole evidence and to ignore it is then to give credence to this argument that we don't know what the purpose of the drainage ditch was. Maybe it was for the town. Maybe the town wanted to do it. My client gave up $440,000 and a mile of property. I mean, a square mile. It was 2,300 feet times 30. It was 6,000 square feet of property to put in this ditch for the purpose of draining Lexington Woods outflow in and through the ditch to Lapp Road. And I don't think that the purpose of the contract could be any more clear. But again, I know we could argue about that all day, Mr. McLaren and I. So I wanted to point out, and the third thing that we rendered meaningless, the first one is Marinaccio's right to divert into the ditch. If it can't handle the Lexington Woods flow, he can't divert into it, so that's a meaningless clause. The second is economically feasible. The town could always do a ditch.
Counsel, you made those 2
Yeah,
arguments.
the third one is, Judge, there is a requirement in the contract, it's in paragraph 11, that says when the town performs on the ditch and does, obviously they're going to be excavating, right? They can't take the spillage and put it on Mr. Marinaccio's in a way that obstructs the drainage from his property. So right there, we know that the drainage of his property is important to this contract. We know that it's not an afterthought. We know that that's a focus of this. So if we need further evidence or indication of why this clause, why the ditch requirement is in the contract, we know that drainage of Mr. Marinaccio's property is important. So for those 3 reasons, I submit you cannot accept the town of Clarence's interpretation of the contract.
In order to give meaning to all of the provisions of the contract, including the 3 that you've just pointed out, we have to assume that there's a purpose to this drainage, and it was to transport the water across your client's property and not allow for the overflow to happen.
That is right, Your Honor.
I think we got it.
Thank you. Appreciate your time.
Case 965, Citibank versus Bailey. Proceed, counsel.
Good morning, Your Honors. May it please the court, Kyle DeDone on behalf of the appellant Arthur Bailey, improperly named herein as heir to the estate of the decedent David Bailey. This is an appeal that arises from the denial of a motion to dismiss in a residential mortgage foreclosure action. The trial court's order constitutes reversible order because the decedent, the borrower in the action, died prior to the commencement of the action. As a result of the death of the borrower, it deprived the trial court of jurisdiction over the matter. Essentially, upon the death of the individual, any later commencement against him individually would be a nullity. The matter itself is void ab initio, and therefore everything that follows from the commencement of that action is likewise a nullity. And with that issue, we have the complaint is a nullity and may not be remedied by substitution. The plaintiff in this matter sought to substitute Arthur Bailey as an heir to the estate of David Bailey. But there is no permissible way in which the plaintiff can do that in this case.
They tried to do it through John Doe 1, but in Wendover, we encountered the same situation, and we did not approve of it there.
Justice Lindy, as you mentioned, that's exactly correct. The Fourth Department took up this exact matter, almost factually identical in Wendover Financial Services versus Ridgeway, in that the borrower died prior to commencement. Notwithstanding the death of the borrower, the plaintiff named the borrower, as happened in this matter. The plaintiff sought to substitute an heir for the decedent. In Wendover, they this court provided a discussion of 3 different ways in which substitution could be permitted and declined to extend that to the plaintiff. And I submit that
At the time the John Doe was referenced in the complaint, the Bailey, was Bailey deceased at that point? He wasn't, correct?
David Bailey was deceased prior to the commencement of the action.
Prior to commencement of the amended complaint.
Prior to the commencement of the original action. The original action in and of itself.
So I guess that's my point. So with respect to that allegation, if you're going to try and substitute somebody in, it should reference the fact that you're substituting somebody in for somebody that's deceased, and that was not done in this case.
That was not done, Your Honor. But beyond that, the substitution of somebody who is deceased prior to the commencement of the action is not permissible. As we mentioned in Wendover, the 3 provisions that are...
But if in fact they're not trying to substitute for the deceased, but rather they're trying to substitute for Arthur Bailey, who's an heir to the deceased, in his capacity as heir to the deceased, right? Not for the estate. You still can't substitute somebody who's an heir to this unless you identified that as a potential John Doe. And they didn't do this here.
No, he cannot be substituted as an heir after the commencement. The commencement itself is a nullity, but beyond that, to get to your point, substituting an heir as a John Doe, he would have had to have been named and served in the original complaint as a John Doe. That did not happen. Arthur Bailey was not served as a John Doe until after an ex parte order amending the complaint and naming him as an heir was granted by the court. And to add to that, as in Wendover, as the Second Department also took up recently in 2020 in Federal National Mortgage Association versus Tudor, when there is an intention to substitute an heir for a John Doe, you have to be absolutely clear that that is the intention. I think from the papers in this case, from the factual setup of this case, the timeline, it is clear that that was not the intention. The substitution in the ex parte motion very clearly delineated that it was their intention to name him as an heir. That was not the intention at the time that they named the John Doe defendant.
Do we even know
complaint.
if Arthur was an heir of David? I know they're brothers. There's some indication that David died without a will, but doesn't necessarily follow Arthur's an heir.
We don't know that. In fact, Arthur Bailey has proffered to the court that he has no interest in this property and therefore should not be substituted as an heir.
But if the death was without a will, he'd be a distributee by statute, right?
By intestate statute,
Yeah.
he would be considered one of the potential class, yes.
Potential class of interested people.
Yes.
Right, okay.
So just to add to that, this is not an irregularity under CPLR 305. So amendments should not be permitted under that section. Under section 1015, where we have substitution if a party dies, that is not available to the plaintiff because the individual died prior to the commencement. And under section 1024, which is what we're discussing with the unknown parties, for all the reasons that we've mentioned, that is not available as well. Arthur Bailey is not a tenant, an occupant, a person or a corporation claiming any interest or lien upon the premises. Therefore, there can be no proper substitution. There is no proper party
I think we have that
for the
argument,
estate.
Counsel.
Okay. Respondent has argued that because this is a mortgage foreclosure action, there are specific exceptions that an heir can be named under limited circumstances, an heir can be substituted. The respondent provides a litany of cases which, if the court would like, I'd be happy to go into, but I think we can summarize and just simply say that the difference between this case and all of the cases presented by the respondent is whether the plaintiff named the heir, distributee, or co-owner of the property at the time of the commencement of the action. That was not done in this case. It was not done in Wendover.
And those cases are all distinguishable based on that.
They're all distinguishable based on that. There are a few cases that they present and where substitution was permitted. However, those are equally distinguishable by the fact that the individual borrowers in those cases died after commencement, which allows the plaintiff to avail themselves of 1021 and 1024.
You should begin to wrap up, counsel.
Your Honor, respectfully, with the remainder of my argument, I'm happy to submit on the papers. I respectfully request the court reverse the trial court's order and grant the appellant's motion to dismiss.
Counsel, thank you.
Thank you.
Case 966, Ewald versus Erie Insurance Company of New York. Proceed, counsel.
Good morning, Your Honors, and may it please the court. Kelsey Shannon for the plaintiffs' appellants, Daniel and Rebecca Ewald. We have a dispute here over the application of an ensuing loss clause in the faulty workmanship maintenance exclusion of the Ewald's homeowners policy. The two sides are proffering, I think, two different interpretations of how those two provisions intersect. Our position, which I submit and I'll discuss, are supported by the case law, is that it applies if there is a loss to a different sort of a different part of the property than where the faulty workmanship happens, and that loss is not otherwise excluded. The defendant's position is that you need some sort of different type of peril to occur. You need fire has to result from water, water has to result from fire. I would submit, and before getting into the argument for our interpretation of it, that even under the defendant's version, there are two separate perils here. There is a faulty workmanship peril, and there is the water damage resulting from the release of water.
So the plumbing that wasn't done properly here, that
Correct.
caused the leaking, you're saying that that's one peril by itself, and the damages of fixing that's not covered by the policy.
Correct.
But the result of that plumbing lack of proper workmanship is the flow of the water. That's the ensuing damage. When the water flows, it's causing damage to other parts of the house as the water flows down, and that should be covered under the contract.
Correct, and I would say that's supported by, starting with the language of the policy.
Does the fact that it's a sudden occurrence make a difference?
Well, I think the sudden is obviously a predicate to coverage, right? We need a sudden or fortuitous loss to create coverage.
Because that is covered absent the exclusion.
Correct, and in that way, this is a lot different than some of the other cases we're looking at, where the subsequent loss or is excluded for another reason. You know, in County versus Broome, that's a pollution case. The loss that they're seeking to get covered under the ensuing loss is excluded. Here,
It's exactly what is excluded.
is exactly what's excluded. Here, there's no dispute, right? There was a denial on various other bases that said the water damage is excluded. They abandoned those below and are solely proceeding on the faulty workmanship exclusion. And again, as Your Honor said, that's covered in our view.
Right, your main point is that the ensuing loss provision, the exception here for the ensuing loss, can't resurrect a peril that's not covered. And in this case, that's not the case. In the case from the town of Hamburg, Playtech, there was the ensuing loss tried to resurrect water damage, which was not covered.
Correct, and I think
Your case here, they're trying to resurrect coverage that, a peril that was actually covered.
Right, and I think the easiest way to look at this is if we weren't talking about the cause of the break, right, and we were just looking at what happened, that loss would have been covered. In Playtech, that wasn't true. It was a flood. That loss wasn't covered. And I think, you know, the cases, even that defendant cite, make this same point. And you can read through them and they say, okay, you know, we're not paying you for the cost of redoing the work. And that's what I would submit this exclusion is designed to cover. And you know, there's
And you didn't seek coverage for the faulty workmanship, for the repair of the the faulty
Correct.
work.
And you know,
faulty pipe.
there's a suggestion, I think, in the defendant's briefs that this is the exception swallowing the rule here. And I actually think many of the cases that defendants cite makes clear that that's not true, because in fact, the cost of repairing faulty workmanship in many cases can be massive. You know, L'Aquila, which is a Southern District case that the defendants cite, what happens there is they get a contractor in, the contractor puts some concrete in, the concrete's not bad, they discover it right before anything happens, and they replace it, they go to the insurance company, they say, hey, we just had to replace all this concrete that we put in, here's our claim. Insurance company says, no, that's faulty workmanship, it's not covered. Fine, right? That's the same thing as the pipe here. And then the L'Aquila court, which again is one of the cases defendants are relying here, goes, this is different, right, than if that faulty concrete had fallen and damaged some other property.
How about the time element? They rely on the foot chandler case where there was a faulty electrical box that years later, 2 years later, causes a fire. And that was deemed to be an ensuing loss. Here they say the loss here, the pipe wasn't cemented or wasn't, connected properly, and it was almost, nobody knows how long after the faulty workmanship the flooding occurred, but it certainly wasn't 2 years. It was maybe a day or two. They seem to place a lot of emphasis on the timing of the two losses, one after another.
Right. And I think the reason that's done is because it's a factual distinction from Frucklander, but the important thing is their rule would not have covered the loss in Frucklander, because there is not some sort of different type of loss, right? All that happens in Frucklander, in which summary judgment is granted to the plaintiff insured in that case, so they say there is coverage as a matter of law. What happens there, and as the assumed fact, since it's on summary judgment, is the electrician does a bad job of installing the junction box, that causes a fire. The fire doesn't cause a flood, right? There's not the separate peril that they are purporting to require here. So I appreciate that is a factual distinction, but I don't think it is one that can have legal significance because it has no basis in the rule that they're suggesting the court apply. On the facts here, there's no dispute, right, that the contractors were not actively working at the time that this happened. It happens overnight on August 3rd into August 4th. Even the day before, and if you read their papers, what was happening on August 3rd was just finishing work, was painting and things like that. So at a minimum...
Even if we accepted that there has to be some passage of time, there was probably some passage of time. We have no idea how long.
Right, but it wasn't zero because they weren't there, right? The
Right.
contractors weren't there at the time that this happened. And I think, I don't know what the enforceable rule would be if it's something that's
Right.
more than zero in less than 2 years. How would you possibly draw that line? The last point I'll make before I sit down is, I think, but I'm biased, that our read of this policy is the correct one. However, they have an alternative reading of how these two policies, these provisions intersect, or the provisions in there intersect, and I'd submit, even if we were to believe that both of those are plausible, they need to be read in favor of coverage for the insured. And it's not just me, giving this interpretation. Obviously, it's several courts that we cited from you. I don't think any of those are, other than Frucklander, are more than perhaps instructive. But the Southern District in 5-Star saw a situation very similar to what's here. It's under Pennsylvania law, but on this issue, I don't think Pennsylvania law differs from New York law. We cited a bunch of cases from other jurisdictions. And the last point, we cited the adjuster from Erie, who had the exact same reading of this policy when he first looked at the claim. With that, unless your honors have any questions, I'll rest on my briefs.
No questions, counsel. Thank you.
Thank you.
Your Honors, good morning. May it please the court, Marco Sircone for the defendant. Excuse me. Justice Whalen, I'd like to address the issue that you had first raised with my opponent regarding, that there's no coverage for the faulty workmanship, but the resulting flow of the water should be or could be covered. And I would submit to you that interpretation is incorrect. The policy makes very clear that we do not pay for loss resulting directly or indirectly if it's caused by or resulting from faulty or inadequate design, workmanship, construction, or materials. And we clearly have a situation here where these contractors that were hired by the plaintiffs were working in that area. They used the wrong, they were trying to connect PVC piping with PEX piping. They were using the wrong cement. They clearly created this issue, and as a result of their workmanship, which was flawed and faulty, the pipe releases, the water comes into the house. That's one event. That is not a parceling of, the piping is not covered, but everything else is covered. This isn't an ensuing loss situation, because what we have is one loss. What was the loss? The water coming into the house. This court, in the Kula decision in 19...
Well, the pipes, of course, had to be, the faulty workmanship had to be repaired, though. I mean, yes, there's water damage that infiltrated the house and caused all sorts of damage, but the work that was done erroneously, it was done poorly, also had to be fixed.
But the work that your Justice Peredato, and my response to that would be, this court in the Kula in 1995 decision that was issued by this department said that the most direct and obvious cause is what should be looked at for purposes of an exclusionary clause. So there's coverage for water damage here, but it's excluded based on the faulty workmanship exclusion. This water damage doesn't occur but for the contractor's faulty workmanship.
Well, you could make the same argument in fruit handler. The fire wouldn't have occurred but for the faulty workmanship.
But that goes to my second point, Your Honor, which is in the Platek decision, in order to have an ensuing loss, it requires at least a new loss to the property. Here, there was no new loss to the property. The property was damaged by water from the very get-go.
So you're saying, so counsel, let me ask you this. So let's just paint a different scenario here, and let's say that the workmen are on the premises.
Sure.
They're tying into a water system, and they use the wrong equipment, and they bang through the pipe, and immediately the water is going everywhere. They search the house for a shutoff. They don't know where it is. It takes a while. There's a lot of damage.
Mm-hmm.
Your argument would be the argument you're making right now.
Absolutely, Judge.
And that is that this is one event. This is not a second event. And as a result, it can't be deemed ensuing loss.
Exactly.
Right? The difference is that if there's now a fix that's done, a workmanship that's done, and it's sealed up behind a wall, the contractor leaves, and then at some period of time later, maybe it's a day, maybe it's a week, maybe it's 4 weeks, maybe it's 2 years, it gives way because of faulty workmanship. Would you say if it was 2 years later, that would be a separate event?
Well, Judge, I think it depends on the peril that occurs, because the ensuing loss doctrine clearly says that there has to be a new loss to the property, right? So if you look at the ensuing loss doctrine was created in 1906 as a result of those San Francisco fires, the San Francisco earthquake. So the San Francisco earthquake happens, and all of the policies of insurance at that time had an exclusion for earthquake damage, right? But the earthquake happens, and then there were issues with gas pipes, and fires started erupting in the days and weeks following that earthquake.
So it seems to me, though, instead of describing it as an entirely separate event, it has to be, the damage has to be to, as they say in fruit handler, to wholly separate property. The property that's damaged has to be different than the defective property. And that's how I'm viewing this case.
Well, and Your Honor, respectfully, you're parceling out the loss into two separate losses when that's not what we have here. What we have here is one loss.
That's the question before us, I think.
Right. Water. The loss that occurred was water damage, but there's a provision in the policy that excludes coverage for water damage if it's caused by faulty and inadequate construction and design, which is exactly what we have here. Those contractors in the week or two before this loss occurred were in there. They were manipulating the shower. They were manipulating the pipes. They used the wrong cement.
Let's get back to my
Sure,
question, though. If this happens 2 years later,
Two years later, I would submit to you there's a lot of intervening factors that could have happened in 2 years. It could have been wear and tear. It could have been something else
so
that
you're not
caused
here
it.
making that argument if it's 2 years. It's because it happened right away.
Correct.
And it's one event.
Correct. It is clearly one event based on the facts of this particular case.
The reason for these policies was the earthquakes in 1906. What if the earthquake where there's no coverage for earth movement, but there is coverage for fire? There's an earthquake, gas, and immediate fire all at the same time.
Right.
Under your theory, it all occurs at the same time, it's not an ensuing loss.
Well, in that particular instance, if it had occurred simultaneously or within a short,
Or within, like here, a day or two?
yes,
Fire?
like for example.
It's not an ensuing loss in that situation?
It's-
Earthquake, next day, fire. That's not ensuing loss?
If there's an earthquake and there is, you've got a period of days or a period of weeks, and that damage, that fire damage causes additional damage later on, then I would submit to you, yes.
I'm
it would
talking
be
about a
ensuing.
day or an hour or 5 hours later.
Well, if the
That's what we're
earthquake,
talking about here. But
if the earthquake causes damage to the structural integrity of the building, there's going to be no coverage for that, okay? But if the earthquake causes damage to the pipes, which then subsequently start a fire at the property outside of the structural integrity that is not related to the structural integrity that was caused by the earthquake, then I would submit to you that fire damage would be covered as an ensuing loss, okay? But you've got to have, and the case law is very clear on this, you've got to have a new loss to property. It cannot be all one and the same like we have in this particular case.
Right.
Counsel, wouldn't your argument with respect to the pipe loss, and I know we're kind of getting a
Sure.
little bit far afield here, but it's kind of interesting. If there is an earthquake, and say a gas line fractures, that's not the foundation, that's a
Right.
gas line.
Right.
Gas is seeping out into the house, and then 5 hours later, there's an ignition, and the house goes up on fire. You would say, I think, that's not ensuing, because it's all part of one event, because it was within 4 or 5 hours.
And I would agree with that, Judge.
All right. I think we understand the
All
argument.
right, thank you. If you have any other questions for me, otherwise I'll rest on my papers. Thank you.
Counsel. Case 967, Grooms Yarborough versus Carter. Proceed, Counsel.
Good morning, Your Honors. May it please the Court, Jason Telak here for the plaintiff appellant Margaret Grooms Yarborough. This appeal is about whether a plaintiff in a personal injury action can be required to answer questions during her deposition about medical conditions and treatment unrelated to the body parts affirmatively placed at issue in her bill of particulars.
Counsel, let me ask you this. First of all, this is an abuse of discretion standard, right? We have to find that the court below abused the discretion in this order, right?
Correct.
Okay. And what the court below was doing, I think, was saying, look, there's a difference between, which is not unusual, it happens all the time in all these cases, right? There's a difference between evidence that is admissible before a jury versus evidence or information that can come through discovery, which the rules in New York are broad in terms of that, right?
Correct.
But your argument, I think, is they're broad, but it doesn't mean everything, and that the plaintiffs in these cases don't give up all privacy rights to everything simply because they commenced an action. We can't have a situation where discovery is being had of medical information that is completely unrelated to the claim being made. Otherwise, we might have a chilling effect on plaintiffs where they don't bring the action because of the chilling effect, right? And that's certainly not a policy, public policy we'd want in the state. But that becomes a balancing act, doesn't it? And isn't that best left for the judge below who's got the discretion to determine what should be allowed in discovery and what shouldn't be allowed in discovery? And in this particular case, it seems that from the record that the court below was saying, this is what we're going to allow to go forward, but come back in if you've got a problem, and I'll address it. And isn't that how this should be? We should allow that to go forward?
Well, Your Honor, in this case, in particular with the issue of privilege, I think the trial court below went against the well-established precedent from this department, which states that when you bring a personal injury case, the plaintiff waives the physician-patient privilege only with respect to the physical and mental conditions that are affirmatively placed at issue.
But what the defendant is arguing, as you know, is that for damages, loss of enjoyment of life, future damages, life expectancy, her medical conditions her condition now, how she's able to get around, how she's able to live, how long she's expected to live are all relevant to the damages issue, so that they are in controversy. Even though she didn't hurt those particular parts of her body in this accident, they are relevant to damages. What's your response to that?
Well, Your Honor, with respect to the life expectancy, there is no expert medical opinion here saying that any of the conditions that plaintiff has are going to shorten her life expectancy. There's no factual predicate for that argument. It's mere speculation calculated to justify a fishing expedition into unrelated medical
So if they had an
conditions.
expert, a medical expert who said somebody who's suffered a heart attack or had some other conditions has a shorter life expectancy, then they could get it would not be privileged?
There would be an argument then. We don't have that here, though. There is no evidence of that sort. There's no factual predicate in this case to show that plaintiff's life expectancy is going to be shortened. And without that, we're left with nothing but speculation to justify a fishing
Isn't that what
expedition.
they're trying to find out? Really, what might underlie a plaintiff's life expectancy? And you have a fairly unusual case where you have somebody with a very significant medical history on top of now an orthopedic injury. Life expectancy, doesn't that impact every single case where there's a permanent injury alleged?
That's correct, Your Honor. If that is the rule, then any plaintiff's case where there's a permanent injury alleged would put life expectancy into question, and that would throw out physician-patient privilege. That would open up the floodgates, and you would be
Cradle to grave.
cradle to grave. You'd be entitled to get any information about any condition.
If it affects loss of enjoyment of life or life expectancy, for example, not that's the case here, but somebody had stage 4 cancer, wouldn't that be relevant information for trial on future damages?
If there was a medical opinion that talked about shortening life expectancy, perhaps it could be, but we don't have that in this case.
Right, but the problem is, as they point out, it's your burden. You're moving for the protective order. You have the burden. They don't have the burden. You don't have a medical expert yourself who says these conditions don't affect life expectancy or enjoyment of loss of use of life. They say you have the burden, not them.
Well, once we assert that something is privileged, to get around the privilege, I would submit that then it becomes the defendant's burden to get around the fact that something's privileged, to show that it is actually in controversy in the case. That would be the Dillenbeck decision from the Court of Appeals. It would be their burden to prove that these unrelated, unclaimed issues that are not asserted or affirmatively placed at issue by the plaintiff are actually in controversy in the case. If the defendant's version is accepted here, anyone who claims a permanent orthopedic injury, and in this case, the injuries are very limited. They're limited to the pelvis, the sacrum, the hip. This isn't a case involving wide, sweeping allegations where the plaintiff put her entire medical history at issue, like would be the case in Boya versus Benz or in Geraci versus National Fuel. This case is more akin to Castro versus Admar, where there are orthopedic injuries claimed. Yes, we're claiming that they're permanent, but that's not enough, based on the precedent from this department, to open up the floodgates and to allow unfettered discovery of any unrelated medical conditions. And here, the conditions that they're seeking to get discovery on are wholly unrelated: COPD, emphysema, bronchitis, respiratory failure, heart attacks, hypertension, breast cancer. These are wholly unrelated to the fall itself or the injuries claimed. So they're palpably irrelevant, but beyond that, they're privileged. The plaintiff has never...
Relevance isn't the standard in discovery here. All we're talking about is, because of the broad discovery, we're not trying to determine whether this is relevant for purposes of trial.
Correct.
Right? That's really not the standard
Well,
the judge below was dealing with.
Well, I mean, under CPLR 3101A, discovery, to be discoverable, has to be material and necessary or relevant. So that is the preliminary threshold.
Or could lead to material that was material necessary.
But even beyond that initial threshold inquiry of whether it's relevant, you have to look at whether it's privileged information under CPLR 3101B, because under CPLR 3101B, privileged information
Right,
is
and
not discoverable.
The problem I have with that is that they're just not asking out of the blue. Have you ever had this? Have you ever had this? They have a good faith basis to ask about these conditions because they were voluntarily disclosed by your client when she turned over medical records. They were right there in there. So they just want to ask about conditions that were already disclosed. And So it is not as though in a run-of-the-mill case, they're just going through a checklist, fishing around for prior conditions. This is already, the cat's out of the bag here on these conditions, voluntarily so.
Well, as our initial discovery responses, we provided HIPAA authorizations, which are limited by the body parts. And as part of that, they got the hospital records. And in hospital records, oftentimes they list prior medical history, prior surgical history. And that routinely happens in these cases generally. But that alone doesn't waive privilege for any unrelated condition that's not asserted in the bill of particulars, that's not affirmatively put at issue by the plaintiff in the case. Here, the plaintiff isn't claiming these other unrelated conditions. She hasn't waived her physician-patient privilege. She's asserting that. And my understanding of the privilege law, especially at depositions, is that if you don't assert the privilege, you can waive it. So plaintiff wasn't willing to waive privilege for these other unrelated conditions. She asserted it. She moved for a protective order. The protective order that she moved for is consistent with the precedent from this court, especially the Castro versus Admar case and the line of cases cited in my papers. And it was an abuse of discretion by the trial judge in allowing these type of questions to be asked.
Counsel, we'll take a look at that. Thank you.
Thank you, Your Honor.
Good morning, Your Honors. Michael Pretch on behalf of the respondents. I will try to just hit the high notes here. I agree that medical information is privileged until it goes towards an issue that's a controversy. In this case, the plaintiff has specifically affirmatively pled that she is going to have mobility issues for the rest of her life. The information that we sort of tangentially went after during the deposition were related to her mobility. I don't think that it's crazy to say COPD, emphysema, these cardiac and these respiratory issues, which appear to have been affecting her mobility prior to this accident, are discoverable when she claims to have mobility issues stemming from this accident for the rest of her life. So her mobility and her life expectancy are issues at controversy in this matter. The court didn't really speak on this previously, and so I just want to quickly say that this is also the least intrusive manner in which we could have gone after this information. We did not request any authorizations that were not freely given by the plaintiff at her own discretion. These were medical conditions that were in her medical records, and we sought to ask her about them at her deposition. That's not to say we won't ask for those in the future, but it's to say that we went after this information in the least intrusive way possible. If defendants are unable to ask these questions, which were asked with a good faith basis, then they are effectively blocked from getting information that might be material to and necessary to the defense of the case. And with that, Your Honors, unless there's questions, I would rest.
No questions, Counsel. Thank you.
Thank you, Your Honor.
Case 968, Carroll versus Niagara Falls Memorial Medical Center. Laws, proceed.
Good morning. May it please the court. I'm John Loss from Connors LLP in Buffalo. Today in this medical malpractice appeal, I speak for Dr. Mark Perry, a radiologist, his professional corporation, and Radiology Solutions Associates, PLLC, his employer. The motion court was wrong, and so the question for this court was, how wrong was the motion court? So if we start, there were 22 allegations to begin with. 21 of them were not opposed below. Nonetheless, the motion court fully denied the motion on appeal. The plaintiff has not opposed the fact that those allegations should have been dismissed under the Bubar case. I know I was back before Your Honors, three of you, on this matter, on the Siemendorf matter, and went through a whole series. So under Bubar, 21 of the 22 should have been dismissed outright.
Mr. Loss, can I just entertain me a little bit so I can ask a couple questions? If I've prepared a few questions, and I'd like to read them and ask you those questions.
Sure, absolutely, Judge.
All right. So you're familiar with Appellate?
Yes.
All right. In Appellate, we rejected the contention of the defendant that he was entitled to partial summary judgment with respect to those allegations in the bill of particulars not specifically addressed by the plaintiff's experts. Would you agree then that, in our later case law, we have not explicitly overruled our holding in Appellate?
Well, you haven't used the word abattoir itself, but I would say that even going back beyond abattoir is the CPLR itself, which allows the motion court to be able to grant summary judgment on partial issues. In other words, what we're really trying to do here is to cut down what the trial is going to be about. And if
well, even in Appellate, it indicated that bill of particulars are merely an expansion and an amplification, and not generally something that relates to a claim itself. It's just an application of that claim.
But it's part of the claim, and so under the CPLR, under 3212G, the trial court, if there's 22 allegations and 21 of them aren't opposed, there's no sense in going to trial on the ones that everybody agrees shouldn't be an issue. And so what I had done the last time I was before the court, Justice Montour, was in Siemendorf, is to show that in Bubar, for instance, it was Justice Whalen, Justice Lindley, and Justice Perodato that said, listen, under Bubar, we're going to get rid of the ones that you didn't oppose. Since that time, and I remember Justice Bannister asking about it too, all 12 members of this court have, in post-Bubar, agreed that that was the correct decision to do, whether it be the Pasek and Noga case with Justice Bannister, whether it be Pasek with Justice Perodato, whether it be Revere for Justice
Well,
Whalen.
wouldn't it have been then on the requirement of those courts then to identify that Appellate was being overruled? We're not going to follow Appellate anymore. That's just too general. I mean, why should we follow it?
Well, I don't know that necessarily has to be the situation because, I mean, first I would argue Appellate was wrong in light of the statutory provision of 3212G and whether the court...
Well, it's 3212G set forth in Appellate.
Well, 3212G, whether it was or it wasn't, it's...
Well, wouldn't you specify 3212G notifying the plaintiff that you better address these or they're going to be held as being, if you do not identify them, we're going to take them out?
No, you don't need, I don't think that you need to put them on notice of that. I mean, because the plaintiff here, and by the time the motion's being made here in this particular case, meaning here in the Carroll case, Bubar was good law. I mean, anybody that practices with the medical malpractice field knew and should have known that if you don't oppose an allegation, and so there's no question here that Dr. Perry...
Well, that's what Appellate said. We're not going to do that. You're not requiring you to oppose all those.
Right. Well, even if it's a situation where the court sub silencio, without expressly mentioning Appellate is still the correct decision, and it's the one that's been followed by this court.
Yeah, look, we have a conflict in our law, to be honest. We have Appellate from 2008 that's been ignored as of late. We haven't disavowed it. We don't follow Appellate in non-med mal cases. We pare down allegations all the time in bill of particulars in other negligence actions. But I think what Justice Montour is referring to is we have some conflicting case law out there that has been ignored as of late, but hasn't been disavowed, and that's creating some confusion.
Well, to the extent there is any confusion, Justice Lindley, then this court should end it here in Carroll and say, yes, we meant what we said in Bubar, we meant what we said in Pasek, we meant what we said in Noga, we meant what we said in Revere.
The difference between Bubar and Appellate, if I remember, and I have the cases in front of me, but in Bubar, no question of fact was raised at all, right, by the plaintiff?
Correct.
So arguably, Appellate and Bubar are not in conflict.
And if that's the direction the court wants to go, that's fine, but...
The conflict in our decisions comes thereafter with Pasek and Revere, and those seem to be clearly in conflict with Appellate.
And to the extent that they are, I mean, as a practitioner that does medical malpractice, and I said this the last time I was here with everybody but Justice Whalen and Justice Montour, I mean, a summary judgment motion is a trial, and except I have the burden of proof. So I say, okay, there's 22 allegations against me, as in here. all of them should be gone, and the plaintiff says, well, there's only one that we think is even worth pursuing, and I'll get to that in a minute. Well, at that point, the trial's been streamlined. I mean, if there's any other decision here, then what we do is we go to trial and we go back before the trial judge, and all of a sudden, what, I'm now defending against 22 allegations
Right,
at
your
trial?
point is that everyone benefits from winnowing things down and clearing things up, what's going to be tried. Do you know, by the way, how the other departments handle this? Do they follow Abatoy's approach or the more recent Revere approach that we have here?
I have to confess, I don't know honestly, Judge, but I would just, I mean, I just think it makes sense from a judicial economy trial. I mean, I just did a trial last week, and it was a situation where I made a motion for summary judgment against X number of allegations, and the motion court dismissed all but one, and then the other ones were out on Bubar. And then we went to trial on the one issue, and it still was a trial for 3 weeks.
We do it on serious injury.
Yes.
Seems like every term, there's one negligence cause of action complaint, not more than one. Bill of Particulars alleges serious injury, 3 or 4 categories.
Right.
We go through it, we say you met it on one, and we send it to trial on one, we dismiss the others.
Right.
That's what you're asking us to do here. That's consistent with Bubar and Revere and so forth. So the question is, are we going to continue to recognize a special rule for med-mal cases from Abatoy, which didn't provide a lot of reasoning? Are we just going to follow that and have a little separate cases where we're not going to allow the defendant to pare down the allegations? That's what we have to decide.
And to address that here, I mean, to some extent, the issue's not even raised by in other words, the plaintiff here isn't saying, hey, follow Abatoy, affirm, rely on Abatoy. I mean, they've waived that in their brief. And I understand that this issue is going to keep recurring because this is the third time, twice I've argued it, once one of my associates argued it. So it's going to keep coming up. And there's no reason that a medical malpractice case, Justice Lindley, is in any way different from the serious injury or any other type of case. And it's in the trial, again, the trial that I had for 3 weeks the other day, there would have been 20 allegations, and I would have missed today's argument.
We understand that.
Trial.
Do you want to address the one particular theory in the Bill of Particulars that the plaintiff did dispute?
I do. And so the sole remaining allegation is failing to recognize, diagnose, note the presence of a DVT during an ultrasound. Again, no question that Dr. Perry meets his burden of showing that there was no negligence and no causation. So the burden...
Didn't you also state that there was no appropriate confirmatory follow-up?
Right.
Okay.
Right.
And you stopped there. I wanted to make sure that was part of it too.
Well, no, except the only thing that the confirmatory follow-up was not with respect to Dr. Perry, because Dr. Perry as a radiologist would be discreet. The only allegation that the plaintiff's radiologist did was just with respect to not saying that you should have seen a blood clot on the DVT. So the confirmatory follow-up wasn't an issue as directed as to Dr. Perry, Justice Montour. So the situation there is, so they had to then show both triable facts on both negligence, malpractice, and causation, and they didn't do it on either. And the key there is, and I'm just going to rely on Justice Peridotto because, oddly, it's just the luck of the draw. I know who's here. But in the Campbell case, which started out with saying, listen, you've got to rely on the medical evidence. And thereafter, in Hope A.L., Ochino, Wilk, Bubar, those were all cases that Justice Peridotto was actually on the panel and said, yeah, this doesn't meet the burden. And what the problem is here is if you listen to what the evidence is, the evidence, what they're saying is, he says, well, let's look at image 9, and I think image 9 shows a clot. That's what the radiologist says. Well, wait a minute. Amy Guerra, who's done thousands of ultrasounds, fills out a sheet, looks at everything. She sees it dynamically, not a static image. She's seeing it, and she writes negative. There's nothing there. Gives it over to Dr. Perry. He confirms that independently. He confirms that as well. And so what you have is, and I put it in reply, and Justice Piggott always taught me, crystallize it in the reply. And here's the problem. They never address, well, what about images 1 and 2?
I know.
What about the waveform
analysis? I saw that argument, but your expert, Perry, he doesn't go through he saw no problem in any of the slides, in his expert affidavit. He's his
Correct.
own expert. He says, I've looked at there's no evidence of DVT in any of these slides. Plaintiff's expert says, well, yes, there is in image number 9. You can see a clot there. Now what you're saying is, well, plaintiff's expert ignores 1 and 2, which don't show a clot. You got to look at all, it's a 30-image study. You got to look at them all in totality. But your expert, if your expert had said, look, 9 looked a little questionable, image 9 looked a little questionable, but I looked at 1 and 2 and it showed that there wasn't a problem, therefore I concluded it wasn't a problem. He didn't do any of that. He saw no problem in 9, 1, 2, and all the 30. So you're addressing an issue. You're saying that 9 isn't a problem because of 1 and 2, but that's not what Green said.
But the problem.
I'm sorry, Perry said.
But the point about that, though, Judge, is you have to look at it in some summation in conjunction. And so it's, yeah, if there's a 30 images, but if 1 and 2, and this is where the problem is, 1 and 2 do not show a clot. The waveform analysis does not show that there's a clot. There's no audibility change. And that's inconsistent with saying it's a clot, and he doesn't address that. Here's the example I would give.
It's inconsistent with saying that there's evidence on image 9?
Yes. Here's the example I would give. One of the first medical malpractice case I ever had was there a clip on the ureter, okay? So the plaintiff put up a plain x-ray film, and it showed the ureter with the surgical clip, front view. But then when you looked at everything else, you know, the side view, this view, you could see, oh, the clip really wasn't on the ureter when you looked at everything all together.
Where, that's a good point, but where in Dr. Perry's expert affidavit does he say the clear images in 1 and 2 show that there's not a problem in 9?
Well, because what he says, he looks at all 30 images and says, all 30 of these images are fine. 1 through 30 are fine. The plaintiff's expert says, well, 9 shows a clot, but ignores that 1 and 2 don't, and ignores the waveform analysis. That's the, so in other words, when we're talking in the case.
Not to beat the drum over again and over again, but Perry doesn't even acknowledge there's a problem in 9.
Right. He doesn't acknowledge the problem in 9 because it's our opinion that there is no problem in 9.
Because of 1 and 2.
But because of 1 and 2 and the waveform analysis, I mean, an argument on appeal. That's, I mean, in other words, it is medically impossible for there to be a clot on 9 and not be a clot on 1 and 2, and for the waveform analysis to not have an audibility change.
But does your expert say that?
That's what Dr. Perry says, yes.
He says it's impossible for there to be evidence in 1 and not in image 9 and not to appear in 1 and 2?
That's what he testifies to at his deposition, where he says there's no audible change in blood flow through the vein depicted on wavelength analysis. And the same thing with the fact on images 1 and 2. Color image showing blood. Image 1 shows flowing blood filling the lumen of the vessel. Image 2 shows no echogenic material within the lumen of the vessel.
But follow up though, where does he say, and because of that, there cannot be the same finding in 9 in contrast to what your opponent's saying?
Well, because when he makes his affidavit as the proponent of the summary judgment motion. So he makes that affidavit and then they come back and say it. But what they do is they haven't addressed all of the evidence. I mean, what I'm saying here is to go to your point, Justice Lindley, yes, there are 30 images. I'm not disagreeing with you at all on that. But he says if you look at all 30 images and the waveform and you look at every single piece of evidence, there was no clot, there was no DVT, and their expert cherry picks one static image. One static image, not dynamic, not compression, not waveform, not the fact that Amy Guerra, looks at it right there and she writes out that there's nothing there. And he says, I'm just going to say this one thing, but it's completely inconsistent.
It turns out that there was a clot there. Was there not?
Well, that's another good question, and that goes also to the causation point, because this was done on February 25th, and it wasn't until March 3rd, 7 days later, because it was a presidential election year, so it was leap year. So there was 7 days later. That there was presumably a clot, and that sort of goes to what their expert says. We all know, I mean, not all, but yes, you can have the development of a clot. It cannot be there on the 25th and be there 7 days later. And that's the problem on the causation point, which goes again, and I'm going to quote.
Counsel, you're running out of time. You should wrap up.
I'm going to wrap up. I'm just going to say on the causation point again, Martinano, Wilk, both Justice Peridotto cases and Justice Lindley, most of those cases you're on too. So I'm just going to say, you know, the past is prologue, the past is precedent on those points. Please follow the precedent on those, and on Bubar, to the extent Abatoy is precedent, don't follow it. If I can be completely inconsistent in what I just said.
Yeah.
All right, thank you. You see, I'm on the appellant side. Okay. I know you're appellant and respondent. Yeah. Okay.
Mr. Collins, proceed.
Yes, good morning, Your Honors. If it please the court, John Collins on behalf of the plaintiff. Supreme Court properly denied the Perry defendant's motion for summary judgment, but erred in granting summary judgment in favor of the Niagara Falls Memorial Hospital. As to Dr. Perry, as the court has already alluded to, Dr. Perry interposed his own expert affidavit saying, I looked at all 30 images, everything looked good, there was no indication in any of them that there was a blood clot. Basically, that was an extended mirroring of his very brief reading report where he said, everything looked good in essence. But in opposition, plaintiff interposed an expert affidavit by a radiologist who, looking at the image for the left common femoral vein, using the compression study where the ultrasound transducer is pressed against the body, it is intended to compress the vein. If there is no clot, everyone agrees, then there is what's called wall-to-wall compression. And in the absence of wall-to-wall compression, it is evidence of the existence of a clot. Now, Dr. Perry, when questioned about this lentiform shape, kind of a lentil-shaped disc that appeared in image 9, according to our expert, he said, well, it's mucosa in the vein. By contrast, the ultrasound technician said, no, it's fat or muscle beneath the vein. Well, our expert disagreed with both the radiologist and the technologist and said that is clear evidence of lack of wall-to-wall compression, and it also clearly indicates the presence of a blood clot.
What about Mr. Loss's argument that, okay, 9 looks suspicious, but if you look at 1 and 2, it shows that there's nothing wrong with, there's no clot in 9, and your expert didn't, just focused on 9, didn't take into consideration any of the other 29 images?
Well, I think, as the court has already alluded to, there's absolutely no expert proof in the record from Dr. Perry or the hospital that the image of a clot has to appear in each test. They are 3 distinct tests, and Dr. Perry never asserted that, if it doesn't show in all 3, it's like a slot machine. You need 3 images or it's meaningless. Our expert looked at it and said, this image, which is created differently in a totally different manner than the other 2, shows the presence of a clot. And Dr. Perry said, in essence, although he never addressed image number 9 in particular, there was no clot. And he said, I didn't see anything in any one of them. So I think that the fact that the expert on behalf of plaintiff did not assert that he saw anything in either the color flow study or the augmenting study that would, corroborate the presence of a clot, at most creates an issue that can be raised on the cross-examination of the expert, and presumably would be, but I think it is nothing more at this juncture than a question of fact, because he was definite in his interpretation of the compression study, saying no wall-to-wall compression, that is a clear indication of the presence of a clot. And, so I think that what we have is,
Do you care about the other 21 allegations in the bill of particulars?
Well, I would, did not really address, Abatoy or Bubar in our brief. I would just ask the court in that to, keep applying Abatoy in this, and the trial court, denied Dr. Perry's motion for summary judgment in its entirety, and I think at this point, that was proper.
Mr. Collins, this is a case where the plaintiff sees the defendant one time, okay? Has one issue, goes to the hospital, talks to the technician, what's done by the technician is reviewed by the doctor, and then goes elsewhere and never comes back. Would you think that this would be an Abatoy situation, because it's really not divisible or broken apart into 13 different things? It's really about one visit and one, not a continuum of care, but one particular time. I guess I'm saying is I can imagine a world that Abatoy and Bubar coexist, because there are some situations where, in my view, like this, it's one event that you're complaining of, one test, one visit, one event, as opposed to cases that may involve surgical care, follow-up care, failure to do a bunch of things along the way. Maybe that's more of a Bubar situation, where you can, separate out or segment out the different ways in which care was given to a plaintiff. What do you have to say about that?
Well, I do think that, because there was one visit and, a discrete visit, there can nevertheless be, as a result of that, multiple bases on which to find that Dr. Perry's reading of this, and he obviously did not see the plaintiff personally, as is customary with radiologists, but that there can be multiple bases for finding that what he did in reading that study and in failing to discern the presence of the clot, which would have led to, increased, studies at the direction of the personal care physician, if he had properly conveyed that information to the treating doctor, that there are multiple, bases on which you could find that what Dr. Perry did was wrong, and that therefore, there can be, as plaintiff has alleged, multiple, findings or reasons for, his, a finding that he committed professional negligence.
But most of these allegations in the bill of particulars clearly don't even apply to Dr. Perry. Most of this is failing to get a complete medical history. Well, he never met with her. His job was just to read those scans, to read those images. And so many of these are just plainly don't apply here. And it's as if the plaintiff is just threw in the kitchen sink with all these allegations, and I don't know what would be the harm, and your expert ignores all of them. They don't seem to apply. What's the harm in just saying for trial, we're not gonna proceed on these? Because they were ignored by your expert. And by you in your brief. You don't seem to care about these other claims. Why not just get rid of them?
Well, again, I would just go back and say that I think that, under Abatoy at this juncture, they should stay in. As to the, failure to determine history, I note that the Dr. Perry did read and rely upon that fact statement by the technologist who did indicate the history of the plaintiff, her complaints about this Charlie horse type pain, swelling. And so, it is clearly something that, if it were not to be considered by the doctor, why would the hospital, why would the technologist even bother providing such information to him? So once it's provided, then I think it does raise a question of, well, should he have asked for more? If he's going to look at it, as a professional.
But your expert didn't opine that he should have.
He did not, I have to acknowledge. If I could just wrap up by briefly addressing the issue of sole proximate cause, which Dr. Perry raised. During the course of argument, there was a question, or at least a discussion of, well, the fact that this occurred some 7 days after, did that constitute some sort of, proof that there was no proximate cause between the clot that our experts saw on, in the image that was taken on the 25th, and, the clot that eventually resulted in the bilateral pulmonary embolism. But there's no proof, and it was not argued on appeal, that, that is a basis for finding lack of proximate cause. That is, that the pulmonary embolism arose from some other condition. The only argument as to sole proximate cause that was pressed on appeal is the contention that because plaintiff saw her personal care physician after the ultrasound study and was referred to an orthopedic practice by that personal care physician, and neither one ordered subsequent testing that might have revealed the clot, that there was somehow a severance of the causal connection between Dr. Perry's malpractice and the ultimate injury. Dr. Perry acknowledged that treating physicians rely upon his interpretation of the Doppler study to determine if further tests are needed. And it's also well established that a medical professional who commits malpractice can escape liability by showing that a subsequent treating physician was also negligent. Taken together, I think those certainly raise a question of fact as to whether Dr. Perry's misreading constituted a proximate cause.
We'll take a look at that, counsel. Thank you.
And I'm also here as an appellant, Your Honor. I know I used a lot of time on the first point regarding Dr. Perry, but I submit that the trial court erred in granting the hospital's motion for summary judgment. There are three independent bases upon which it could be held liable, and there are triable questions of fact as to each. The first is basically just vicarious liability based upon respondeat superior. Plaintiff alleged that Dr. Perry was acting as the hospital's agent, servant, or employee, and the hospital, to obtain summary judgment, had to establish via proof in admissible form that that was not true. It failed to do so. It didn't submit any kind of affidavit or documentation by a hospital administrator or documentation generated by the hospital. It essentially relied upon Dr. Perry testifying that he was a member of a group that read diagnostic imaging at the hospital.
And in your
But he
view,
was
that's
not
not,
asked.
in your view, that's not enough?
It's not enough because he was not asked and did not testify that he was not a hospital employee as well as being a member of the group. He was not asked if he was an agent, if there were any kinds of relationship, that would give rise to a finding of agency or control by the hospital. In fact, he was asked, do you have any position at the hospital? And he said, I'm the chief of the Department of Diagnostic Imaging. Now, he was referring to himself individually there, and there's no indication that that's not a paid position. The hospital didn't establish that. Even if he was not a formal employee, I think the fact that he, as an individual as opposed to a member of a practice group, is the chief of the hospital's Department of Diagnostic Imaging raises a question of fact as to whether he was at least an agent or a person who, in his professional capacity, was under the hospital's control. Secondly, I think there's a very strong argument that in any event, there is at least vicarious liability based upon apparent agency. Plaintiff testified that she was directed to go to the hospital by her physician who said, go get this Doppler study. She went to the hospital, had it done, and she left. She never met Dr. Perry, and he read it at the behest of the hospital. She had no reason to doubt that she was getting an ultrasound imaging by the hospital, and if they chose to use an ostensibly independent contractor to read it, she certainly had no reason to believe that. Her referring doctor had no reason to know that, and I think that that gives rise to a very strong apparent agency.
You should wrap up, counsel.
And then thirdly, I think that the hospital could, independent of all of that, be held liable for the malpractice of Amy Guerra, the technologist who, according to the hospital's protocols, interpreted the study and, you know, reported it to the doctor, who then read it and said at his deposition, yes, or in his affidavit, yes, I concurred, I agreed with her reasoning. So in some hospitals, the hospital points out that, you know, technologists simply do not interpret. All they do is conduct the test and send it on. That is clearly not the case by Amy Guerra's admission here. She, as a professional, had the ability to read it and did read it, and I submit misread it. And even though Dr. Perry subsequently misread it himself, although in a slightly different manner, her negligence, I think, you know, gives rise to liability, vicarious liability for her
We'll take a look at
acts
that,
as an employee.
Thank you.
Good morning, Your Honors. It is still morning. Adam Dysinger on behalf of Niagara Falls Memorial Medical Center. Your Honors, I submit that the lower court properly determined that the hospital met the standard of care in performing the plaintiff's DVT ultrasound on February 25th, 2016, and that no act or omission by the hospital staff, including their ultrasound tech, Ms. Amy Guerra, was a proximate cause of the plaintiff's claimed injuries. The detailed expert affidavit submitted in support of the hospital's motion for summary judgment, the affidavit of Dr. Sherman, established that the ultrasound performed by Ms. Guerra was a high-quality exam, which was in all respects appropriate and within the standard of care. Dr. Sherman opined that Ms. Guerra, as the ultrasound tech performing the study, had absolutely no duty or responsibility to interpret the subject ultrasound. Co-defendant Dr. Perry confirmed that the review of the ultrasound and the interpretation of it was his responsibility as the radiologist. Ms. Guerra testified that as the ultrasound tech, she's not authorized to interpret ultrasound studies and diagnose blood clots. Her testimony was that as an ultrasound tech who has performed thousands of these studies, she's able to discern what she may perceive to be the presence of a clot, but she is not authorized, she cannot diagnose them, she does not speak with the patient regarding the study after it's done. She leaves that up to the radiologist. In performing the ultrasound, Ms. Guerra was fulfilling an administrative duty, an administrative role to facilitate the completion of the study. That study is then sent to the radiologist for interpretation, which our expert, Dr. Sherman, opined showed no clot. He agreed with Dr. Perry's interpretation of the study. The fact that Ms. Guerra circles a minus sign on a form, which is sent along with the radiological study to the radiologist at the conclusion of that study, simply indicating that she is the ultrasound tech who performed the study and visualized the study live, did not perceive the presence of a clot, doesn't create a duty for the hospital relative to the interpretation of that study.
How about the vicarious liability with respect to Dr. Perry?
Sure, I submit that the lower court also properly determined that the hospital is not vicariously liable for Dr. Perry.
In your motion, you put in proof that he was part of this group, but I don't see that there's anything saying that he wasn't perhaps also an employee of the hospital or some sort of agent of the hospital.
I believe we submitted Dr. Perry's deposition testimony where it was clear that he is a member of this independent group of independent contractors that reviews studies at several different institutions in Western New York, that he reviews studies in Medina, that the Summit Health.
But should we assume that because he's part of that independent group, that it's to the exclusion of any other responsibilities he may have vis-a-vis the hospital?
I think his testimony established that he is not employed by the hospital. He's employed by and is a member of this separate independent group of contractors. I think part of his testimony was that he reviews images from his home for various institutions, which included the hospital. I think the testimony submitted in support of our motion, Dr. Perry's testimony, was sufficient to establish that he was not employed by the hospital. The second point on vicarious liability is, I think plaintiff failed to raise a question of fact in their opposition with regard to Dr. Perry's status as an independent contractor. Plaintiff didn't submit any evidence in opposition showing that the hospital made any representations to the plaintiff that Dr. Perry was its employee, or that plaintiff relied on those representations when she was seeking the ultrasound. I think plaintiff's deposition testimony, which was submitted in support of our motion, established that her primary ordered the study for her, scheduled the appointment for her. The plaintiff's testimony is that she entered the hospital through the main entrance, checked in directly at the radiology department. She testified that she understood the hospital wasn't going to perform a physical assessment of her. She understood that she wasn't going to be an inpatient. She understood that she actually wasn't going to see a physician that day for a clinical evaluation as to whether she had a DVT. I think that our motion papers appropriately established that the hospital can't be vicariously liable for Dr. Perry, and I think the lower court got it right. And unless your honors have any questions for me, I'll rest on.
Thank you, counsel.
Thank you.
Case 970. People of the State of New York versus Barnhart.
Good morning, Your Honors.
Counsel.
May it please the court, Faris Rumi appearing on behalf of the appellant, Mr. Barnhart. Your Honors, as the court is aware, Mr. Barnhart pled not responsible by reason of mental disease or defect to all counts of an indictment in March of 2021. In June of 2021, the county court held an initial hearing. At that hearing, Drs. Nelson and Gray testified as psychiatrist and psychologist. The examination reports of the doctors was also submitted into evidence. At the conclusion of said hearing, the county court found that the people had proven by a preponderance of the evidence that the appellant suffered from a dangerous mental disorder. This is what Mr. Barnhart is contesting today. And Your Honors, I would submit that per the Court of Appeals case law cited in my brief, the people were required to prove by preponderance of the evidence at least one of three factors.
Counsel, let me ask you this. If the expert testimony is that the doctors were continuing to try and work on some type of treatment protocol that was going to have an impact, and that short of that, accomplishing that, and having a treatment protocol that impacted this particular, well, your client, he was going to be dangerous to himself or others. How do you address that?
Your Honor, I address it as follows. As the Court of Appeals also noted, as cited in my brief, the sentencing court cannot rely on mere expert speculation that the defendant will commit a violent act in the future. It's clear from the Court of Appeals case law that the people have to show either that in this case, the appellant suffered from a history of relapses into violent behavior or substance abuse or non-compliance with treatment recommendations. And ultimately...
And there's record evidence of those very things in this case before us, right?
Well, Your Honor, I would submit that if Your Honors look at the record, especially the testimony of both experts and their examination reports, they both admitted that the appellant did not suffer from any recent violent ideation or intent. He'd shown insight over the course of his treatment. He was certainly less at risk of harming himself or others than when he entered treatment. He had no history of substance abuse. Not only that, but they both testified that overall he did comply with his treatment. And I would submit that no one is 100% compliant with treatment, but they both testified that he did take his medications. He never physically harmed anyone at the RPC. Even in terms of the Camelot incident.
Does it make a difference, though, in terms of your argument right there, that if the doctors are saying that the treatment protocol that he's complying with in some measure, they're not sure that that's going to have the effect that it needs? In other words, to make him not a danger.
It doesn't, Your Honor, because
they're the medical experts. They're the ones saying, we're not sure that this is even the right treatment protocol.
I agree that, Your Honor, I would agree that the sentencing judge obviously was not a medical expert, but the Court of Appeals case law has made it clear that it's for the sentencing court to decide, not the experts. And ultimately, there can be cases where there is expert speculation. And ultimately, Your Honors, in this case, both experts established that Mr. Barnhart had no history of substance abuse. He was compliant with his treatment. Even in terms of the Camelot incident, he never actually harmed or even tried to physically harm the employee of the RPC. And when other staff arrived, he did take his medication. Not only that, but even when the experts talked about the incident where the appellant punched a teacher in the head, that was about 14 years ago. That was remote in time. I would submit that does not establish a pattern of relapsing into violent behavior. Ultimately, Your Honors, the experts did show that the appellant is mentally ill. They showed that he had a history of being verbally abusive at times and he needed treatment, but they also established that he had no substance abuse issues, he had been compliant with treatment, and he had not engaged in any pattern of physical violence, especially while he was being treated at the RPC.
And that any finding beyond that would be speculative.
That is correct, Your Honors.
I think we understand the argument, Counsel.
Thank you, Your Honors. In that case, I'll rest on my brief.
Thank you.
Thank you.
Case 971 and 972, Council Financial 2 LLC versus Bortnick. Proceed, Counsel.
Good afternoon, Your Honors. May it please the Court. Ed Markarian for Defendant Blaine Bortnick. Your Honors, there are two issues. The first issue is whether the plaintiff incorrectly brought this action under CPLR 3213, summary judgment in lieu of complaint, because the amount they are seeking to recover cannot be ascertained from the financial instrument or payments thereon. And the second issue is whether Mr. Bortnick should be allowed to interpose an answer to plead his causation, collusion, and settlement defenses.
So let's go to the first issue. You rely on the agreements to use what are the names of the cases? Passeretta and Albuquerque fees to reduce the amount that's owed, and you say that's not the type of de minimis extrinsic proof that is typically allowed under the statute and the case law.
Correct, Your Honor. Those were course of conduct modifications of the guarantee. They were not payments on the guarantee, and you can see that by comparing page 142 of the record with 121 of the record. 142 of the record is the plaintiff's self-made, self-serving, it's not a financial instrument, it's what they call the guarantee payment chart. And to get to the number they're suing on, they show the payments, they call them payments, from Passeretta and Albuquerque. And they say that's why they're only owed 4.5. But when you look at page 121 of the record, you see what the actual payments are. That's the, quote, payments chart. And most of the payments were not paid toward the debt guaranteed by Mr. Bortnick. Most of the payments were paid to loans that he did not guarantee. So you've got a course of conduct modification, which now you can't have that under 3213. It's got to be on the instrument and on the payments.
It almost actually seems like a separate agreement, a separate kind of agreement that was like a separate oral and email confirmed agreement, something along like that.
It's murky now, and 3213 is not for murky. Is it? You know, we could call it a separate agreement. I submit, Your Honor, it's a modification of the guarantee itself. Whatever it is, it's murky. And for 3213, it's got to be a documents case.
You say they need to serve a summons complaint, bring a summary judgment motion, then you can get into this.
Yes, Your Honor.
Doesn't seem like your client has a great defense to the guarantee, but that's not for today.
Correct, Your Honor. And I would like to note on that, you know, one of the arguments that the plaintiff is making is, well, we're suing for less, you know, be grateful, we're suing for less. But the problem is, if you're suing for less, the question is why, and are you still suing for too much? And that brings us into the other Bortnick cases. It's not just Passeretta and Albuquerque, it's Iannucci and 3 other cases. And we know that Mr. Bortnick alerted the plaintiff to Iannucci and said it's ripe for collection, go get it. And under the documents here, under the course of conduct, that would suggest he's entitled to a further reduction of his guarantee. We need discovery to know if the other Bortnick cases came in. We know that the bankruptcy trustee paid $1.2 million to the plaintiff We don't know if any of the, quote, Bortnick cases were part of the $1.2 million. And they say that, well, our deal was with the trustee in bankruptcy, we could apply that towards interest. That may be, but the course of conduct with Bortnick may say that he's still entitled to a modification based on the course of conduct.
Is your argument relative to these two fees, or the application of these two contingency fees, is that how you distinguish this case from the Sullivan Law case that we decided this summer?
Yes, Your Honor. So we made two, I would say, submit thorough arguments about why it's not an instrument for the payment of money only under 3213. One, this court addressed in Sullivan, and now we have a disagreement between this court and the First Department.
Right.
And, you know, for appellate preservation, I'm not waiving that issue, but that's not what we're talking about today. That's a completely different issue. That is because in the guarantee here and in Sullivan, it was a guarantee for payment and performance, so we said it wasn't a guarantee for money only. This court
And you
did
did
not
make the
agree with
same
that.
argument in this case, but
We did,
we
but-
rejected that in Sullivan Law
Correct.
in August.
So we're just preserving that. But we have a
Right.
completely separate argument here that was not at issue in Sullivan, and it's the argument we're talking about. We have a course of conduct modification. They're not suing for the amount of the financial instrument, so it's not a 3213 case. I'd also like to note on the substance that Mr. Bortnick should be allowed to amend or to interpose an answer, because this is a very unusual circumstance. There are 5 loans. He only guaranteed part of the first loan. And then we have this relationship, and again, this is a limited record, but it's not disputed so far, where Bank of America says to the bank, here, the lender, if any of your borrowers are in default with you, you are in default with us, and then we can call in all of your loans, which explains this very unusual course of conduct by the lender in this case. The first loan comes in, the borrower, the law firm, is not doing anything it's supposed to be doing. For some reason, the lender gives them a second loan. And the reason for that is they don't want to go into default. They don't want the borrower here, the law firm, to go into default because now they're in default with Bank of America. And then, so they use Peter to pay Paul for the first loan. Then they have an affiliate give a third loan, and a fourth loan, and a fifth loan. They build this loan pyramid. And poor Mr. Bortnick's only guaranteed part of the first loan. So the question is whether this is such commercially unreasonable conduct that we're into Canterbury now. Judge Levine's opinion in Canterbury, where he says, if you cause the situation which triggers the default, if the lender causes it, then the guarantor is off the hook. And we would like to be able to plead that defense and have discovery on it. The collusion issue is similar. It's the relationship that the lender had with Mr. Little was very unusual. We would like to explore collusion. And the record here indicates there was a settlement. They secured an affidavit from Mr. Bortnick saying, sign the affidavit so we can use it against Little and the law firm. He does that. The affidavit says in it, there's a settlement in principle. We've got to work out the details. We'll do that in good faith. The record suggests they did do it in good faith. Mr. Bortnick says, we agreed on it. They told me it was agreed on. They told me all material terms were agreed upon, and they deny that. That's a question of fact. We would like to be able to assert that defense. So we ask that this court reverse.
Thank you, Counsel.
May it please the court. First of all, we have a situation where there is no denial that the borrower defaulted on the promissory note. Instead, we have, on page 4 of Mr. Markarian's reply brief, the defendant asking this panel to reconsider Sullivan, which, as Your Honor noted, Justice Peredato noted, is 4 months old.
And we've already denied re-argument on Sullivan.
Okay, I'm going to move past that issue.
But the question is this case different? And from my perspective, as I understand your argument, you say that this proof about the application of these contingency fees is exactly the type of de minimis extrinsic proof that's permitted under 3213 in the case law?
And there's another reason why it should be permitted. We are giving credits that arguably aren't due, trying to do the right thing.
Well, I know, that's a pretty, it's a fairness argument, and it's pretty appealing, but I'm not so sure 3213 cares about it.
We went through the math, and have the documents narrowed to several pieces of paper affixed to the 2 affidavits by Ms. Payne, and we think that's sufficiently minimal. The argument that the mere existence of something that's a course of conduct needs to be looked at in terms of the loan documents themselves. I've been at this 47 years. These are the broadest waivers I've ever seen. Just noting what he's
I think the question from our perspective is how far from the instrument do you go in order to satisfy the de minimis extrinsic proof?
Well, here, I'm very sincere about the fairness thing. If it is $900,000, and that is real money, at least in my household, but it was in his favor. So this is really like a situation where if there needs to be an exception, this has the justification because it's for the benefit of the defendant. And we got to remember, there are complaints about the applications of money. The total debt owed to my client is almost $10 million. It's almost $10 million. Little and Robinson is liquidated, gone. We got $1.2 million out of it. Little himself, gone. Hubbard, gone. We got the settlement with him. He helped us get some money. He paid nothing, gone. Everybody's gone. So even if we sued for the full $5.5 million, all these payments that came in would be getting credited to the interest and the shortfall, because we do have the right as the creditor to apply first wherever we want. And that's case law and that's contract both here. So where we did the right thing.
Where's the fairness there?
That's a good point, Judge.
You want to be fair here, but where's the fairness?
But having done this for a couple years, every lender in the world applies at first interest. Our Internal Revenue Service, our Department of Taxation and Finance applies at first interest.
But you made an argument to Judge Peredato about, we're fair here, we're fair people here. You know, Go ahead.
I will say that when you sat on bunk about 20 years ago and explained how to argue to this court, you said first convince the court that you should win, then give us a way on how you can win. And I remember when you weren't there yet, Justice. But it's the exact fact that we gave him the credit for steering the Passeretta dollars to us, I think is justification for that not being within the note. And nobody says everything has to be within the note. You're exactly right. It's how far can we go beyond the note? I would argue if you're going beyond the note to raise the amount, it should be a different standard than if you're going beyond the note to reduce the note. We are giving credits. These aren't debits. And I think that changes the calculus. And I hate to see this thing become a full lawsuit, because when you look at the law on an absolute unconditional guarantee, absolute unconditional, we have 7-year-old Court of Appeals precedent in Cooperative Financiere, which says when it's absolute and it's unconditional, you can collude. That case said, we're not even going to look at collusion because that's been waived. And that case cited to another case which said, if you sign, and here we have an experienced litigator sign, if you sign an absolute unconditional guarantee and then contest that it's not absolute, that it's not unconditional, you've committed fraud on the lender. So here, the emphasis in Cooperative was, we are going to honor these instruments. But there was another theme in there. Mr. Markarian, and we're friends, we go back a long way. He says that Cooperative ratifies Canterbury. But when you read the language, what it says is we're going to narrow Canterbury, and Canterbury's dicta, because the holding is there's liability, and if Canterbury were being relied on, it would be a finding in Cooperative of no liability. So it's just dicta, and it narrows it. And in Canterbury, the lender actually prevented the payment by shutting down. Now, that was a lockbox. And just to repeat how lockboxes work, the money never hits the seller. The money goes right to a post office box, and then the bank sweeps. So when you shut that down as a lender, the cash flow ends. Here, what's alleged is essentially the old California-style lender liability. I was overserved. That was like the drilling case that this court would not adopt from the Mick Whipple malfeasance at M&T. This court has never adopted I was overserved, I was overlent as justification for denying a creditor recourse. And I have cases that support me on that. Globe Services, Parmalat. My opponent, his main argument, collusion, he does not have a case that says the further lending is grounds for denying liability. And my dad was an accountant. I gotta say something here. If I get money, say $1 million, I put an entry on my assets, $1 million. I put an entry on my liability, $1 million. I didn't get more insolvent. My insolvency didn't deepen. That's a push. If anything, these further loans, which are his main complaint, delayed default, they didn't cause default. Getting money it's not like drinking where another drink makes you drunk. Getting money doesn't make you broke. It puts off when you become broke. And when you look at the release, let me speak to the release for a second. Mr. Bortnick's wife, his wife, another professional, never agreed to sign the mortgage, never agreed to sign the confession of judgment. Do we think that this deal is done where the wife has not signed on? There's no testimony in any of their papers that the wife had ever agreed, and we provided in our papers where that was an open issue and she was traveling and she was unavailable. How can we take as a given there's a settlement when the co-owner of a magnificent townhouse in the city hasn't consented? So I don't see where that's going to be a given that you could take that. But more importantly, 2104 applies, because if you look at the Spaniolis affidavit, the affidavit by Mr. Bortnick and the stipulation of discontinuance without prejudice were the same day, January 24th of 2019. And importantly, Mr. Bortnick cannot claim detrimental reliance. He told the truth. That's not consideration. He cannot claim detrimental reliance. He didn't perform the legal services. We drafted it for him. The irony is, if you listen to Mr. Bortnick, what we should have done was, when we first lent the money 6 years ago, we should have immediately called default, and then he would have owed $5.5 million instead of $4.5 million. He's complaining that he's owing $1 million less. I think that has to be weighed in the decision of the court. Thank you for your patience.
Thank you, counsel. Case 973, in the matter of Lemon versus Town of Scipio, I guess. My apologies.
Scipio, yes. Good afternoon, Your Honor. Afternoon.
Yep.
Good afternoon, if it pleases the court. My name is Joseph Castelline. I'm an attorney with the law firm of Young Summer. We represent the petitioner appellant Elgin Lemon. This matter is an appeal of a decision issued by the Cayuga County Supreme Court from December 2021, where the court essentially confirmed the actions and decisions on the merits of the Town of Scipio Zoning Board of Appeals as to an application by the appellant. The fundamental issue here is the appellant had a portable camping trailer on his property. The zoning code enforcement officer issued a notice of remedy or notice of violation saying that the portable camping trailer was in violation of a code provision which dealt with camp structures and being set back at least 250 feet. The appellant appealed that to the ZBA.
Arguing that it wasn't a camp and it doesn't apply.
Correct. Well, not that it just wasn't a camp, but also it wasn't a camp structure. The definition of structure is clear that materials assembled, constructed, or erected at a fixed location, including a building, the use of which requires location on the ground or attachment to something having a location on the ground. There was documentation submitted showing what this portable trailer was, showing that others in the area had the same type of
And it
portable
wasn't in a
trailer.
fixed location. Your client's trailer wasn't in a fixed location, but moving back to the camp in a camp, your argument is section 110-3 says a number of trailers, houseboats, RVs in a camp shall not exceed a certain number.
Correct.
You're saying, we know elsewhere, a camp is defined as a trailer, among other things, so, or a tent. And so your reading of this regulation here, the zoning code, is that it prohibits putting a camp within a camp.
Basically,
Putting
it's
a
just
trailer within another trailer, or a
it's
tent within another tent, and that's ambiguous. We're supposed to construe it against it, and then, as you say, the structure. There's all sorts of problems with this. I haven't seen any explanation at any level of this proceeding from the code enforcement officer, from the zoning board, from the town in the Article 78, or in their brief on appeal, of how they explain this tent in the tent problem, or the structure, how this is a structure. I haven't seen any explanation.
There's never been one given. It's unfortunate. My client has gone through this process, especially when there's others in the neighborhood who have the same type of portable trailer.
And they didn't get cited.
No, after my client, first when my client raised it with the town, the response was, well, nobody has filed the complaint. Obviously, the town building inspector can go around, issue violations when there are violations, but then my client fulfilled what was requested, filed the complaint.
The zoning officer has some discretion, though, doesn't he, in terms of when he issues? I mean, if we allowed that to be a defense, that all you had to do was find another place in the town where the same violation was occurring, and there wasn't a zoning officer there to write an appearance on it, that you're off the hook. That can't be the argument.
You're correct. It's not a defense.
Yeah.
What it is evidence to show how arbitrary the Zoning Board of Appeals decision was. That this information was in the record. It's a consistent practice where apparently it's interpreted a different way. Granted, there could be different circumstances. We accept that. It's not a
Just because
defense.
somebody else is violating the code doesn't mean that you can violate the code, but the explanation given here from the code enforcement officer about the other trailers was, well, they're not occupied. They have a tarp over them. But then when you go back to the code, it doesn't say only occupied trailers are prohibited. It says trailers.
Correct.
So it just further, that's the one explanation we saw, that I saw in the record for any determination, and it was, obviously, it wasn't based on the code.
Correct.
But there is, as Justice Whalen has indicated, we have two conflicting theories of law here. Is one, the zoning board's entitled to great deference in interpreting zoning codes. On the other hand, if a zoning code is ambiguous, we're supposed to strictly construe it against the town. So those are the two legal principles at play here, and they're, one favors you, one favors the other.
Well, I think you can read them together in the sense that while zoning boards might otherwise be entitled to deference, it's generally about factual issues, factual determinations. Here, there's nothing factual. There's no dispute about what was at issue, this mobile camping trailer. It was, how do you interpret the local law? Case law is clear that when it's a legal interpretation, you don't have to give deference, but certainly you don't have to give deference when the interpretation is just arbitrary and capricious.
Or if they gave us an explanation for why a camp's in a camp, or interpreting camp to mean, in the context of this regulation, that the real property is a camp, then give us some explanation. Okay, if it's in the zone of reasonableness, we're going to defer to you. But your point is, we have not heard a single explanation for any of these interpretations. All we hear is, here's our ruling, and it's entitled to deference.
Correct. And it just, to us, ignores, well, there's three big arguments here, besides the camp and the camp structure, also the provision about a non-conforming lot. That's in the code. That's section, let's see, that is section 115-1 sub C. It says the minimum lot width and area regulations herein set forth shall not apply to any lot having an area and or width and or depth less than that prescribed in this chapter. The chapter refers to the entire zoning law. Provided that such lot was designated and shown on a subdivision plat, tax map, or deed filed and recorded in the office of the county clerk or town clerk subsequent to December 9, 2015, prior to the effective date. So this parcel, and there was evidence in the record, existed in its current form without the ability to meet the 250-foot alleged setback before the zoning code was in existence. And in fact, the notice of remedy included a copy of the tax map showing the configuration of the parcel. It even showed the frontage on the lake being about 128 feet. You can certainly extrapolate from that, you know, the rest of the dimensions of the property. But that wasn't even addressed. That's another significant argument. So ultimately, the ZBA was clear they just weren't going to have this. They weren't going to agree to it. They were going to treat it differently and interpret it differently, in our opinion, as to other portable camping units, and just decline the entire thing. The lower court did never get into it. Nobody has ever addressed these arguments. Our position is, as laid out in our brief, that the court can decide that. It's a legal interpretation issue. There's no disputed
We'll
facts.
take a look at that, Counsel.
Yes. The second major issue is whether or not there was compliance with the open meeting law. The open meetings law, it's clear that the intent, and this is laid out in our brief, is to allow the public to have access and view and see and hear public deliberations as they're going on. A key part of that is notice of when actually there's going to be public deliberations. Here there was a predetermined vote from one of the board members who, before the hearing, voted on it, put it in an envelope, gave it to the chairperson to open when there was a vote. The chairperson then was aware of that vote. He opened it up, he says it in his affidavit, looked at it and read it, didn't disclose any of that to the public. At the end of the hearing, the record was clear that the chairman conveyed to the applicant, look, the matter is closed for tonight. We have 62 days to issue a decision. We'll get back to you. Even the type
Counsel,
that...
does it make a difference as to whether or not that sealed vote would have impacted the ultimate decision?
It's a violation of the open meetings law. The open meeting law doesn't say, well, a violation only ultimately impacts it. It's a violation. It's clear. It's something that the court has the discretion to annul the entire process. But it also, the chairman then knew about it. Who knows if that impacted? Maybe if the chairman thinks, well, I give great respect to board member A, I might be more concerned to lean in, and maybe other people, you know, feel the same way about the chairperson. So it's hard to tell, but it certainly taints the whole process. But then when there's this vote after the fact, after all the members of the public were asked to leave, and the chairman in his affidavit said, well, we had other business on the agenda already to attend to, and so that's why. They didn't explain at the meeting, well, stick around, we're going to be voting on this later. And if you read their meeting minutes, actually, it's clear that there wasn't, this issue about voting that night wasn't already on the agenda and wasn't something they intended to do, but something they decided to do after the fact. After everybody left and they discussed their new business, the meeting minutes say, members of the ZBA expressed a desire to discuss the evening's hearing, so Welsh asked for a motion to discuss all hearings in any such order. Such motion was made and discussion ensued. So they just decided that night, you know what, we're just going to vote on it, even though we've told all the other applicants for those hearings to go home, and we had other existing business. They then modified their agenda after the fact.
Is that the record? Does the record reflect that they told everybody to go home, or does the record reveal that they were simply going to step away for a period of time?
As to my client, it was clear in our position that the matter is done for the night. We'll issue a decision within 62 days. You know, an hour later, deciding it isn't, you wouldn't say, we'll issue a decision in 62 days. You'd say, we'd issue a decision in an hour, stick around. As to the other individuals, the record reflects that they said, look, we're done with the hearings. These are over. You can stay, so they say here, but we're only going to talk about other scheduled business for the night, which is not what we've already just done. Because if those hearings weren't other scheduled business, why would they say, you know, go home, you know, leave? So, and ultimately, it's really disingenuous and, you know, a violation of the spirit and intent of the open meetings law when it's hidden in secrecy and just not upfront about when they're going to decide something. My client had a right to watch the full board deliberate in public, possibly raise any other issues of concern, plus other people who were there who had made some comments about camps and camps. So you're talking about my daughter can't have, you know, sleep over in her tent because we don't meet the setbacks, which they declined to answer. So ultimately, we think with the open meetings law issue, there was a violation. Attorney's fees and costs are proper in this matter, but more so it appears the provision that allows the court to direct that the board attend open meetings law classes so they get a better understanding of how these open meeting law provisions are intended to work.
Thank you, counsel.
Thank you.
Good afternoon, Your Honors. May it please the court, my name is Rick Weber. I'm from Bond, Shuddock & King. I'm here on behalf of the town of Scipio. Town of Scipio Zoning Board of Appeals. I'm somewhat flummoxed that my opponent would assert that the Zoning Board of Appeals somehow de facto ejected Mr. Lemon from the meeting. There's nothing in the record that indicates that whatsoever. There was a break that was taken. The lower court correctly concluded there was a break that was taken. So I'm a bit flummoxed that he would actually come in front of this body and make that assertion.
Was it on the agenda that they were going to vote on this that evening?
Well, they were going to consider it in a hearing. I don't think they had a specification indicating whether they were going to vote that evening or not vote that evening.
Well, didn't they say we're going to provide a decision within 62 days?
They did say we'd provide a decision within 62 days, but they're alerting him to the fact of a timeline when a decision could issue.
To file a decision, right.
Right.
But we can do it within an hour.
Sure. I get served with a summons and complaint. You know what? I have 20 days to answer it. I can answer it 2 hours after I get it, or I can answer it 19 days after I get it. That is not a definitive, you must leave the chamber now kind of direction. That's absurd. There's nothing in the record that indicates that's happened, and it's a complete misrepresentation. Mr. Lemon was free to stay as long as he wanted. I do think it's interesting, too, that there's this subtle implication that, well, they denied him an ability to participate somehow in the deliberations. Let's step back for a second. That's not how open meetings work. And it's very clear from the record. It's been cited in multiple places in the record, including in Mr. Castelline's papers at both the petition and in his brief, that they had full opportunity to present legal argument and to present the evidence they thought was necessary to raise their position with the Zoning Board of Appeals.
Do they have a right to hear the deliberation of the board or not?
Well, I don't think they were excluded from a right to hear the deliberation of the board. I think it was clear that they were instructed that they were taking a break and there were going to be further proceedings that night.
Shouldn't that deliberation of the board be open meetings? You can't go into an executive session unless it's discussed.
There's no evidence they went into executive session. In fact, the board indicates they did not.
Right, exactly. So it should be, the deliberation should be open to the public.
I believe that's correct, yeah. But there's no indication it wasn't open. And look, I can understand why Mr. Castelline wanted to get on the road and return to Albany, where he came from. I get that. It's a long drive from Scipio to Albany. So I understand all of that. Why Mr. Lemon didn't decide to sit around, I don't know, right? But simply put, there's no express open meetings law violation here. Also on the open meetings topic, and then I do want to pivot, obviously, to Justice Lindsay, to your concern as well. But on the open meetings law violation, the other argument is about this 5-0 vote versus a 4-0 vote. I fail to see how the result was changed. Mr. Castelline's arguments that somehow there was a sealed envelope, so because a sealed envelope had been delivered meant that everybody's voting was now skewed and the results somehow would have been changed. There's just no evidence in the record for that at all.
Harmless error would apply in this situation. There's technical violations of the open meeting law. Doesn't necessarily mean that you have to vacate it, they can be deemed harmless, and that would seem to be a good example of a harmless error if there was error at all.
Yes, that's correct. And we had cited those cases on harmless error. I think the case that we had cited on that, I think we had cited matter of Cooney, right? Matter of Cooney, that's at our brief on 18. Even if they could show an open meetings violation, they'd have to show more than a mere negligence or some kind of harmless error. Frankly, Your Honor, to the court's point, there are a couple of things I want to raise up front. Number one, to affirm the lower court, which is what this body should do, doesn't necessarily leave Mr. Lemon without remedy. Mr. Lemon could seek a variance conceivably. Mr. Lemon could conceivably undertake what all citizens can do and go to his government representatives and say, look, this zoning code needs to be changed.
Counsel, he claims he's grandfathered. He's got pictures of the trailer beforehand.
So I'm glad you mentioned that. That's interesting. The photos of the trailer, while Mr. Castelline was talking, I wanted to find those in the record. Photos of the trailer are 208 to 210 in the record. This appears to be a structure that very much was placed on that property. I do agree that the record is devoid of evidence that has been developed by the petitioner in support of that argument. What the petitioner is basically doing is throwing out a Hail Mary saying, oh, well, geez, it's a non-conforming lot. So because it's a non-conforming lot, that means no zoning codes apply to us. The interesting thing about that is it goes to the point of whether he ever moved that trailer, either on that lot or off that lot whatsoever, at any point in time after the code was entered in. If he wanted to make the argument that he was a non-conforming lot, he has to make the argument that it was exactly that trailer in exactly that position that exactly stayed there, predating the enactment of the code, right? That whole section of the code is a non-conforming uses section of the code. It is not designed to give anybody who thinks they can shoehorn their lot in a pass from any and all zoning enforcement actions. And let's remember how zoning works, because I do think it's interesting that he makes a point of saying, hey, I found examples of other trailers. The way the zoning procedure works is somebody makes a complaint, right, or it comes to the attention of a code enforcement officer. In this case, it came to the attention of Code Enforcement Officer Doyle. He looked at it, he read the town code, he said this clearly doesn't meet the 250-foot setback. There's no dispute, everybody agrees. It doesn't meet a 250-foot setback. No argument here. What Mr. Lemon wants is essentially a variance. What Mr. Lemon wants is to present his own self-serving preferred reading.
Well, what he's saying
is
that he didn't violate section 110-3, and that that provision is ambiguous when it talks about you can't put trailers, tents, houseboats, RVs in a camp, when camp is defined as those very objects.
Well, it actually, because I have that open here, it actually says the number of tents, trailers, houseboats, recreational vehicles, or other portable shelters in a camp shall not exceed the number of single-family dwellings,
Right.
which could be erected on such premises. Now, the first thing I find interesting about that is in his analysis saying, oh, this must absolutely appeal to large-scale camping grounds, places where you're going to put multiple tents or multiple trailers. Why would you talk about single-family homes? If that was the only possible application, if it could only ever possibly be applied to large-scale campings, you would never mention the number of single-family homes that could fit at the
Why
lot.
would you put, why would the town talk about in a camp, when camp is defined elsewhere in the code as any temporary portable shelter such as a tent, recreation, RV, or trailer?
Yes, the camp definition, that's in the record at 229. There's also the structure definition that's in the record at 234. The issue indicates that, well, it's the position of the town of Scipio and its zoning board of appeals that under the Article 78 law, right, it's for the town code enforcement officer to make this determination.
Right, but he's got to explain it. So I'm just looking for an explanation of how does he come to the conclusion that the petitioner's property is a camp?
I think he comes to the conclusion that it's a camp, based on the issue that it is a temporary or portable structure such as a recreational vehicle. And as far as the structure goes, right, the word erected at doesn't necessarily mean construction. It can mean placement.
His trailer is a camp. I think we agree on that, right?
I think so.
And then it says you can't put your trailer in a camp. So you can't.
Right, this is his tent and a tent and a tent.
Right, so I'm just looking for, and we have to give great deference to the zoning board, but I'm just looking for any explanation. Did they ever explain that problem here? How did they interpret his property to be a camp when a trailer's a camp?
Well, the record is, Justice Lindsay, the record is what the record is.
Right.
As you know, I can't speculate on the deliberations because I was not present for the
Right, so
deliberations.
are you acknowledging that there's no explanation in the record or in your brief or in the Article 78 papers for how the zoning board came up with that interpretation? They have a conclusion, they don't have any rationale.
Well, not true. It's very clear that the code enforcement officer Doyle went out, he looked at it, he made the measurement, and he read the code, and he concluded on a rational basis that these are not disparate terms that cannot be reconciled consistently. That was in the record that was put in. It's the initial code violation section. When Mr. Castelline and his client came to the Zoning Board of Appeals, they presented that document to the Zoning Board of Appeals and said, this is what your code enforcement officer has concluded. We disagree with his reading of the zoning code. And as soon as they say, we disagree with his reading of the zoning code, you're in the Article 78 land, right? And in Article 78 land, the case we cited was Carrier. I think a more recent case that this court had is the Wang case from this past July. But at that point, it's deference to the administrative agency.
I apologize for keep coming back to this. Maybe
sure, Justice.
But maybe it's just a problem of me not understanding. But is there any explanation in the record by the zoning board for how you can put a camp in a camp, which is what Section 110-3 talks about?
But that's not what this case is. That's where I think we're having a disparity. And with all due respect, Justice Lindsay, the camp in a camp is a red herring. What we're talking about is, does this trailer on that lot meet a 250-foot setback?
Right, but you can, the reason he was cited is he has a trailer in a camp.
Yes.
A trailer in a camp. And then if you have it in a camp, you can't have a camp structure unless it's set back 250 feet from the property line. So if the trailer's not in a camp, you don't get to the 250. If the trailer is not in a camp, you don't get to the 250.
Right, but then this is where you were talking about the conception of a camp as a lot.
Yeah.
Right? And this is where we start spinning off into pre-existing lots and all this kind of stuff. I think the position is fairly clear of the town. This trailer on this lot does not conform to the zoning code. Now, once that determination has been made, right, the issue is there a rational basis for this? And Justice Lindsay, that if your conclusion is, I don't have a record that's developed well enough to make the determination of how the Zoning Board of Appeals got there, the decision would not be for this court to substitute its own judgment, but to remand it back, send it back to the Zoning Board of Appeals with a specific instruction to say, explain how you reconcile.
There was a question at the public hearing from a resident, a lady was saying, under your interpretation of the zoning board, my daughter has a sleepover and puts a tent on my yard. I'm in violation of this provision unless I have more than 2 acres because it's impossible to have the setback. There was no answer to that, but your answer would be, yes, that tent's in violation.
No, my answer to that would be, you're asking me for an advisory opinion. That's not how the zoning works. The way the zoning works is she can go put a tent in her yard.
And then get cited.
If there's a complaint, she gets cited.
She would get cited under the zoning board's interpretation. She would have to get cited.
I don't know that that's the case. I honestly don't, Your Honor. We're spinning off into hypotheticals that are beyond what we have here. What we know here is this trailer.
That's what we do as an appellate court. We ask hypotheticals
I
because
understand.
our cases are going to affect not just your parties, the parties here,
Sure.
but future parties. But
Sure.
in any event.
But if that were the trouble, if there was a concern amongst this body that was sufficient to say, wait a minute, Justice Lindley has a point, we just don't think there's enough evidence, the correct remedy then would be to return it to the Zoning Board of Appeals and say, listen, have another hearing.
And explain your ruling. Explain it. Just don't give us a conclusion, there's a violation. Tell us, answer these questions.
Right.
Why is
yes.
it? Okay.
But even if the court were to conclude that, the issue of the open meeting law can be resolved now. I don't think there's an open meeting law violation. And if there were an error at all, I don't think it's material to the determination here.
Counsel, you should wrap up.
Thank you, Your Honors. Do you have any further questions?
Very good, thank you.
Thank you.
Case 975, Wells Fargo Bank versus Deering. Proceed, Counsel.
Good afternoon, Your Honors. John Keenan for the appellants. This is a somewhat unusual case as it involves questions attached to an affidavit which was submitted by counsel for the plaintiff in a previous action. which was wound up in 2008. And in that, counsel, in an application to dismissal lis pendens, stated that he had received funds sufficient to pay off the mortgage in that previous action. And that was placed on record in August of 2008. And now the action which is involved here was filed in 2012, alleging default. And as of 2021, that counsel, who's not the counsel of record in this action, submitted an affidavit saying that his previous statements were a mere scrivener's error. And there's pretty definitive case law on that. In fact, saying that the statute of limitations under CPLR 213.6 is 6 years to reform a document which has been placed
They
on.
say they're not reforming, that this is a new document.
Yeah, well, unfortunately, they are trying to reform it because what they're saying is it was a mere scrivener's error. The decision FDIC versus Five Star Lending says that it applies to scrivener's errors.
Well, counsel, I think they also say that your clients knew that it was an error, not just, they temporarily knew it. They made payments after that, which indicated their action that they knew it wasn't paid off, that in fact it was just, they paid enough to satisfy the lender at that point in time and continue on.
I can't make any representation as to that. I certainly wasn't their counsel before 2019, and this is quite distant in the past. And then, without disclosing anything, I can say they've made no representations to me one way or the other on that issue. But I think my position is that the lender is bound by the document that he filed. It's on file for the whole world to see with the county clerk's office, and I think they're bound by it. The other issues, such as judicial estoppel, it's simply that they've taken two separate positions into two separate actions. The 2008 action, they've said it's been satisfied, and in the new action, they say it's still owing. In this case, I think there are real questions of fact as to what occurred, and I think that should have been inquired into by the court.
You think this should go to trial?
Well, I think at least they should have gone to depositions and questioned my people, and I would have had a chance to question the previous counsel. So at least we could see what happened. I think there were questions of fact. That's why I didn't move for summary judgment at the time. But the oddest part about this case is something that's I've never had happen before in my career. On the date this came due, there was obviously a proposed order attached, but I didn't get a call from Judges Chambers or anybody else saying, have you had a chance to review that proposed order? I simply I was copied on an email from court clerk saying, the order's been signed. And there was no indication in that order that the papers we had submitted on the electronic system had ever been reviewed or looked at by the court. So I think that was highly unusual. And I know there were a lot of problems with that court at that time in other cases, but I believe that should simply be enough to have this reviewed, sent back, the order vacated, sent back to the court in Chautauqua County so that we can see what happened in this specific case.
Thank you, counsel.
Good afternoon, Your Honors. May it please the court, my name is Margaret Casino. I'm here on behalf of the plaintiff respondent.
Okay, I'm going to stop you. Why shouldn't you be bound by that document that says the mortgage is done, it's paid for, it's over?
Well, I think there's a couple really important things that this court needs to know. One, the procedural history of this case. Okay, so the law of the case doctrine precludes the current arguments that are being made. This case was commenced in 2011. An answer was filed by the defendants in 2011 through counsel. Nowhere in that answer was there an affirmative defense alleging estoppel. Nowhere was there an affirmative defense alleging payment. The court in 2014 granted summary judgment. It was taken up on appeal, and it was affirmed by this very court. Okay, so his current arguments are precluded there. It wasn't until 2019 that the defendants, through new counsel, are now saying, whoa, there's new evidence. And the new evidence is a 2008 affirmation that was filed in connection with the discontinuance.
Wasn't that evidence
of this-
available all along?
Correct. Correct. There's no new evidence here. How can a defendant stand in front of you today saying, I relied upon this document that was filed in 2008, but in the same breath tell you that they just learned about it in 2019? Moreover, as the court pointed out, the record establishes that defendants made 3 years of payments after that document was filed. There was a prior foreclosure action. They reinstated the arrears. They made monthly mortgage payments under the contractual documents for a 3-year period before this foreclosure action was commenced.
How long has it been since the payment's been made?
So the last payment, the loan is currently due for April 1st, 2011.
So they're still occupying the residence?
Correct.
What about the taxes?
That is being borne by the lender.
So they've been there for 11 years without paying a dime,
Correct.
still in the house?
Correct. And, you know, when it came to the reply brief, I know counsel had tried to challenge the law of the case doctrine, and he made a representation that summary judgment had in fact been vacated. That was never the case. There was a prior judgment of foreclosure and sale that was entered. Counsel filed an order show cause saying, whoa, there was payment, right? And the judge, out of abundance of caution, went ahead and vacated that order and allowed the parties to move for a new judgment. When you look at the record before the court, the referee's findings are supported by the affidavit and the submissions by the plaintiff. There were no submissions by the defendant. The record is void of anything from the defendant, where the defendant actually has personal knowledge, where the defendant actually says, I made payments. This is not a case where you had a defendant relying upon the statement that was made in the 2000 action and then took no action to continue paying. So it would be one thing if the defendants were standing here saying, I never made another mortgage payment because, hey, their paper said it was paid in full. Then that's where the doctrine of estoppel would come in. But when the court takes a look and looks at the record that's before it, you will see that the record establishes that plaintiff is entitled to judgment, that the doctrines of equitable and judicial estoppel do not apply to this case, and that the law of the case doctrine precludes the current argument.
Thank you, counsel.
Thank you, Your Honors.